If defense counsel, if you want to talk to the officer or the ASP assigned to the case, please step outside. If you want to confer, just let either Madam Clerk or someone know that you are present. If you see your client where you don't recognize them with a mask on, or you haven't seen them post-pandemic, let me know so that we can sound out for your client. I've had many an occasion where the attorney would walk in, not realize my client sitting right next to them. So, you know, it happens. So, I have a verdict form. I have a verdict proposed plea for Director Johnson. All right, and Mr. Hubbard, right?
Yes.
There you is.
And Mr. Johnson present.
All right.
Oh, come forward.
Yeah, no, you can have a seat, Mr. Johnson, and you can see that table right there.
Okay.
And then as soon as you're ready, who's going to be the ASG for this case? Mr. McCutcheon. It's my McCutcheon. Yeah. You need to switch that to the Zoom until you're ready.
The judge, yes.
Can you meet this guy?
I'm not.
No problem. All right, Miss James, if you can hear me, how many participants do we have in the waiting room?
Good morning, Your Honor. We have Susan Greenhouse, ASG Riley, PD, Catrice Helen, and PD Wanda Gantz.
Okay, you can let them all in, please. Okay, just 1 second. I knew late in life I had IT started that again. So. Two should be the yeah. Oh, okay. It's really good. All right. Okay, good morning, ladies and gentlemen. My name is Judge Lal. This is the Orca criminal calendar with the State Court of Fulton County for today, October 28, 2022. This is the 11:30 a.m. calendar. I have motions, I have pleas, I have requests to reset. I have, well, just a potpourri of requests for the 11:30 calendar. So we're going to take them one at a time. Just real quick, for my Orca C motion, Orca C as in cat, as in Christina, as in whatever word you want to get for the letter C. Alicia Story is present and Mr. Taylor is present, right?
Yeah.
Okay, you are here for a motions calendar. Do we have Officer Richardson present?
Yeah, Officer Richardson is present. He was required to retrieve some additional paperwork.
Speak up, please.
Officer Richardson is present, but he went to the car.
Okay, so he's on the way. Mr. Taylor, did you want a chance to confer with the officer and the ASG, Miss Marshall Story? Did you want a chance to confer with the officer and Miss Marshall Story before we proceed?
Sure, we can do that.
All right, so when the officer appears, so y'all can step outside and talk, okay? I've got a plea hearing that I'm going to address, so use that time while you're not addressing your cases constructively. Thank you.
Thank you.
All right. So the other case, Jessica, on my Orca C motion calendar, Jessica Ibistanami, represented by Eric Scott Portas. That case is reset to November 18. A separate notice of hearing will be sent to the parties in concern. Second case up in this particular Orca C calendar is John McGee, represented by James Sullivan. Yeah, Mr. Sullivan.
Looks like we're ready. I'd still like to talk to the state and see if we can get some movement.
Okay. Is Ms. McCutcheon with that case? So, all right. And
Officers Paul and Snyder are here.
all right. Did you want to confer with them before we proceed?
With the officers.
I really believe. No. Do you want to confer with the officers and the prosecutor before we proceed with your motions calendar?
I would love to.
You'd love to. Okay, good. Ms. McCutcheon is going to be busy with plea hearing. So, Ms. McCutcheon, any objection to Mr. Sullivan speaking to the officers?
No, I believe you may already have done that.
Not yet.
I don't have any objection. I will get a copy of your report to you.
All right, who are the officers that with whom he's going to confer?
Officers Huff and Officer Snyder. In the very front.
Good morning, gentlemen. This is defense attorney, Mr. Sullivan. He just wants to have a little powwow with you. Would you mind stepping outside with him? Thank you. And if you need your report before you step outside, just let Ms. McCutcheon know. Orca A motions calendar, Ricky Johnson, Mr. Hubbard, we're going to go with that plea hearing. I'm just doing a status right now, okay? You're number one on deck. Matthew Littlefield, do we have Miss Renee Rockwell? Or has Miss Rockwell contacted the clerk's office to get the Zoom? Because I know she does that quite a bit. Okay. Christopher Simpkins, represented by Scott Smith.
Aaron Donnelly from Scott Smith's office. We're ready on that motion.
Aaron,
Donnelly, DOHNALEK.
Sent you the email from Rockwell asking about a reset.
Sorry, guys.
so, is Mr. Simpkins here?
Yes.
Okay, good. And who are the officers in this case? Trooper?
And then Officer Gianella from Georgia State Patrol.
All right, Miss Donnelly, was it?
Donnelly. Donnelly.
Donnelly,
Yes.
okay. Ms. Donnelly, same request. Do you want a chance to speak to, is it Trooper or Officer Gianelli?
Good trooper.
All right. You want a chance to confer?
Sure, Your Honor.
All right, you can step outside with a respectable trooper. Sir, do you have your police report or anything you want to speak? Okay, good. Nikisha Barty. Nikisha Barty. not on-
Your Honor, Wanda again on behalf of Ms. Barty. I am requesting, Your Honor, a reset. I have discussed this with ASG Riley. We are in the process of getting the mental health evaluation completed. I believe Mr. Jordan submitted the order for your signature. We thought that we had an order, but apparently there wasn't one. So we will need to have a reset so that she can get that MAPT completed, Your Honor.
I was notified that Judge Mincy signed it, so if you don't see one signed, please go ahead and resubmit it for my signature. I'd like to get the evaluation commenced as soon as possible. These normally take a reset of about 4 to 6 weeks. Is that what you're looking at?
6 weeks, maybe we may have something by then. If it's possible to reset beyond that time frame, Your Honor, I think that would probably be more reasonable given my experience with the time that it takes to get these evaluations scheduled and completed. And they are able to do it on an outpatient basis.
Okay,
Via Zoom.
is December 2nd or December 9th available? What's our next motions calendar? No, it has to be after that. All right, we're going to reset this case. Just hold on the date. Wycliffe Shakua, that's been reset to November 4th. So on these motions, I have, let's address case number 20 CR 002357F, State versus Ricky Johnson, represented by, Mr. Johnson's represented by Curtis Hubbard. And Mr. Johnson and Mr. Hubbard, if you can stand at the podium right there. Mr. Johnson, yeah, yeah, don't use those doors, yeah, just go all the way around. It's a nice breezeway path, stroll right to Mr. Hubbard, and Ms. McCutcheon is going to stand wherever she's comfortable. All right, let me just go ahead and pull out this case.
If I might, counsel, I'm going to submit a no cross
Oh.
for the DUI.
Yes.
Helping to bring forward one or more charges.
All right, Mr. Verrecki Johnson, you were originally accused of DUI, driving under the influence of alcohol, less safe, and reckless driving from a September 30th, 2018 incident. I guess the state has just submitted a null pros, in other words, a notice of intent to not prosecute the DUI charge. So the only remaining charges pending against you is reckless driving. We're going to proceed with a plea hearing with regards to that remaining charge. Please remember that you have a right to remain silent. Anything you say about the facts of your case, the statements can and will be used against you. You have a right to an attorney, and Mr. Hubbard's representing you. Ms. McCutcheon is the prosecutor for the Solicitor General's Office of Fulton County. She's going to articulate the basis of the plea offer, and then your attorney is going to give me a response, after which I'm just going to ask you some questions to make sure that you are entering a plea that is knowing, voluntary, and intelligently made, okay? For purposes of the plea, this is a negotiated plea.
It is, Your Honor.
That is correct.
May I place your client under oath?
Yes, Judge.
Mr. Johnson, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am, I do.
Thank you, sir. All right, Ms. McCutcheon, what is the state's offer on the reckless driving?
State is recommending that the court sentence the defendant to 12 months to serve 24 hours, credit for the time.
I think you may have to use that microphone.
Yes, ma'am.
Thank
So
you.
a person who's standing at the podium.
Understood.
Yes, the state is recommending 12 months to serve 24 hours in custody, credit for the time already served. Balance on probation, a $1,000 fine, 40 hours of community service, a risk reduction driving class, 1 victim impact panel, alcohol and drug evaluation and treatment, random screens while on reporting probation. Probation may become non-reporting once all conditions have been successfully completed.
All right, thank you. And Mr. Hubbard, do you stipulate, are these the terms to which your client has agreed? And do you stipulate the factual basis, venue, and ID?
Yes, Judge, those are the terms that Ms. McCutcheon just gave to the court in terms of the negotiated resolution, and we do stipulate that there is a factual basis.
All right, thank you. Mr. Johnson, have you consumed any medication or alcohol recently?
No, Your Honor.
And have you understood the proceedings so far?
Yes, Your Honor.
Are you satisfied with your attorney?
Yes, Your Honor.
Is anyone forcing you or inducing you to take this plea offer today?
No, Your Honor.
And you're doing so freely, knowingly, and voluntarily?
Yes, Your Honor.
And I'm sure your attorney explained this to you. If you decide to plead guilty to reckless driving today, you will have to waive your constitutional right to go back to court, have a trial before a judge or a jury, to be able to confront your accuser, examine and cross-examine witnesses, challenge the evidence presented by the state, present any defenses if you choose to do so, and have the state try to prove the original charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
And the attorney has explained to you by entering a guilty plea to reckless driving could impair your driving record, could increase points in your driver's record, could affect other personal matters such as your professional licenses, your residency, if applicable, and so forth.
Yes, Your Honor.
And you also understand that you do not have a right to appeal.
Yes, Your Honor.
All right. How do you plead to 1 count of reckless driving?
Guilty.
Your sentence is 12 months to serve 1 day, credit for time served 1 day. The balance will be placed on probation. Do I have a probation officer in the courtroom or on Zoom? Oh, so, Mr. Johnson, and I'm sure Mr. Hubbard knows where the probation office is. Yes, no?
Is it still in this building?
It's at 132 Mitchell Street in downtown Atlanta.
32 Mitchell.
132 Mitchell Street. You will report to probation next week on Thursday.
Okay.
Making sure that next week's not a holiday. Okay. And make sure you report that before 3 o'clock. Your probation officer should have all your paperwork by then, and they will process and create a probation case. While you're on probation, you will complete the following. And that would include paying $1,000 fine plus any court costs, complete 40 hours of voluntary community service at any nonprofit agency, which is not a school and not a religious organization. You can go to the Atlanta Food Bank, to Salvation Army, you can go to Goodwill. My daughter's favorite is any kind of animal rescue. So you take your pick, but no schools and no religious organizations. You would also have to complete a risk reduction driving program, and the programs are offered on the website with the Department of Driver Services, or you could ask your probation officer which program qualifies. In addition to that, you will complete what we call one victim impact panel, and also go to a healthcare provider to complete an alcohol and drug evaluation. If the evaluation indicates that you may need some treatment or counseling, you must submit yourself to such treatment. While you're on probation, you will be subject to random screens for alcohol and or illegal drugs. And if you've completed all the requirements such as the $1,000 fine, the community service, risk reduction, victim impact panel, alcohol, drug and evaluation, then your probation will be non-reporting. You will still be subject to random screens. All right. Mr. Hubbard, excuse me. Any other questions?
Nothing further, Your Honor.
All right, that concludes this case. Thank you.
Thank you, Judge.
Mr. Hubbard, before you run away. All right. I'm sorry? December 16th, and that was for Ms. Wanda Gant's case, right? All right. Ms. Gant and Ms. Riley, if you're on the Zoom, Barty's case is reset to December 16th at 9 a.m. or 11:30? At 11:30 a.m.
Thank you, Your Honor. Good
All right.
morning.
Thank you, Your Honor. This concludes my business. May I be excused?
Yes, Ms. Gant, have a great weekend. Thank you.
You too.
All right. I'm going to start with Alicia's story, 20 CR 002278F. I have Officer Richardson present.
That's correct, Your Honor. He's present.
All right. So the way this whole place is set up, Mr. Taylor, you're going to be seated at this table where Mr. Hubbard is. Ms. Marshall Story is at the prosecutor's table. Your client will be seated. Do we have an extra chair for your client at this table, defense table right here? And Officer Richardson, you'll be the first witness up. So please come to the podium right here. Thank you. And this is the paperwork right here. Okay. All right, Ms. Marshall Story, if you want to come around next to the officer, the microphone will be there too. And you both can, it's a very awkward layout. I do apologize. But this courtroom has not yet been modified for complete in-person.
So
So-
where would you like me to?
I think you need to be facing him. And also, Mr. Taylor, you can reposition yourself in such a way that you can see the officer and so forth.
Okay, thank you.
Mhm. You're not bound to the table. I just want you all to reposition yourself so that you can ask the officer questions and Mr. Taylor can see and do whatever he needs to. Officer Richardson, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I do.
And what's your full name, sir?
Joel Richardson.
Gerald?
Joel, Joel.
Repeat?
Joel.
Joel. Okay, sir. Joel, and which division are you with? Agency?
Atlanta Police Department.
APD. Okay, thank you. All right, Officer Richardson, Ms. Marshall Story from the Solicitor General's office is going to ask you some questions, and then you're going to get cross-examined by Mr. Taylor, who represents Ms. Alicia Story. We have a motion to suppress and motion to limit in limine, which is essentially a motion to suppress and dismiss. Mr. Taylor, I'm going to dispense with our opening statement and go straight to the motion, okay?
Yes, we don't have one.
You don't have a
We
motion?
have an opening statement.
Okay, good. Now, this is the defensive motion, but Ms. Marshall Story, do you want to proceed first?
Your Honor, I will go ahead and proceed.
All right, go ahead.
Thank you. Officer Richardson, good morning.
Good morning.
Can you please tell the court and direct your responses to the court instead of towards me? But if you can please tell the court how long you've been employed by the Atlanta Police Department?
I've been employed with the City of Atlanta Police for over 11 years.
Okay, and is that your complete stint in law enforcement or have you worked other places?
No, that's it. Just 11 years.
Okay, are you considered post certified?
Yes, I am.
And can you please explain to the court what that means?
I'm able to enforce several laws. I have things in training, in criminal procedure and traffic violations.
And please explain to the court regarding driving under the influence and making arrests of that nature, whether you've had the opportunity to do that as an Atlanta Police Department.
Yes, I have.
In the Atlanta Police Department. Okay, and explain how that training is involved.
Well, when I at the academy, you have a lot of hours. They bring folks in that's intoxicated, some is not. And with the training, you have to test on these people and then they grade you accordingly. After you come out of the academy, you have the opportunity to go to Gypstick to extend your knowledge, which I did.
Now, is there continued training that you have to complete in order to stay post-certified and certified in the area of DUI training?
Every year you have to take a certain amount of classes to keep your post certification. Else you'll be suspended and you won't have arrest powers anymore.
Okay, and were there training standards that you actually had to successfully meet in order to complete the training?
Yes.
And you did meet those standards, is that correct?
Yes, I have to.
Okay, now in your employment with the Atlanta Police Department, have you had the opportunity to make any driving under the influence arrest or conduct any investigations?
Yes, I have.
And approximately how many?
I can't recall. It's been several.
Several hundred, several thousand, several three? Can you give us an approximate number?
Over 11 years, I know I'm missing hundreds.
Okay. All right, now I'd like to direct your attention to March 13th, 2018. Were you working as an Atlanta police officer on that date?
I think it was March 22nd.
March 27th, I'm sorry, 28th.
22nd.
Let me- Yes, directing your attention to that date and time, can you please tell the court what date that was?
I was March 22nd, 2019.
Okay, and were you in the vicinity of 530 Highland Avenue?
Not at this time, I was dispatched to that location.
Okay, so please explain to the court how it is that you arrived at that location.
When I was patrolling that area, I was dispatched on 530 North Avenue, Northeast, from an auto accident, which involved a single motor vehicle.
Okay, and how did you receive that call?
The call came on that a vehicle that struck a fixed object.
Okay, and did you eventually come upon that particular vehicle?
Yes, I did.
And can you tell the court what you observed?
Upon my arrival, I observed a vehicle which collided with the stop sign, and the driver was on the scene.
Okay, and where exactly did you first make contact with the driver?
At 530 North Highland Avenue Northeast.
Okay, and do you see that person that you made contact with in the courtroom today?
Yes.
And can you please?
Wait, before we do that, Miss, Was that person wearing a mask that day?
No.
All right. Do you need this person to remove the mask?
No, I took a look at the video yesterday, so I could identify the person.
All right. Please continue.
Okay, can you?
Your Honor,
please-
if I may, I didn't catch what you said, what you just said.
No, I took a look at the video, so I know I could identify the person.
You,
Looked at the video.
oh, the video?
Yeah.
Okay.
Please identify who you came upon on March 22nd by an article of clothing or another identifier.
A lady in a multicolored mask, multicolored shirt with a black, I guess, shirt underneath or something of that nature.
This is a recorded proceeding. Mr. Taylor, could your client please stand up and lower her mask just for purposes of identification?
Yes.
Okay, and who did you come to?
Thank you.
Thank you. Who did you come to know this person as?
The driver of the vehicle that got into the accident.
Okay, and Your Honor, I'd like to have the record. You know that person's name?
Her name is Miss Alicia Story.
Objection, Judge.
Go ahead.
If I may.
Yes.
I know this was a long time ago, and the officer appears to be referring to his report, which I don't believe is proper in this type of scenario. We would like him not to be able to refer to that report unless he indicates that he does not remember, and then the prosecutor refreshes his recollection of that report. Not to be troublesome or pestering. It just helps us if there's a record showing what he remembers from his mind and what he remembers simply because of the paper.
All right. I'm going to sustain the objection, but I'm going to allow the officer to just glance at the report to make sure that the name was correct, because I am guilty of doing that many, many times. All right. But from this point onwards, Officer Richardson, if you need to remember substantive facts, you need to let your attorney know that you need to look at the report to refresh your recollection.
Okay.
You're permitted to do that. That's perfectly fine. All right.
Okay.
But if you just need to look at the report to refresh your recollection on substantive facts, just let us know you need to look at the report. That's perfectly fine. All right. Thank you.
Okay, you ready to proceed?
Yes.
Okay, thank you. All right, do you recall the weather on March 22nd, 2019?
I remember it was dark, it was clear.
Okay, and please tell the court all of the circumstances again surrounding your communication and your interaction with Alicia's story. What's the first thing that you noticed when you talked with her?
When I had a conversation with her, I got a strong odor of alcoholic beverage coming from her. I observed that her eyes were bloody red, her words were slurred, and when she was walking, she would sway from side to side.
Okay, and what did that indicate based upon your training and experience?
That person is under some form of alcohol.
Okay, and were there any statements made by Ms. Story?
Yes, while speaking to her, she admitted openly that she was intoxicated. And even before I asked if she would submit breath test, she agreed to.
Okay, and is that how it happened? Can you just explain that to the court a bit more? Did you ask her any questions before she gave you that response?
No.
Okay, and is there anything that anyone else stated that would elicit her to make a response of that nature?
No, she was the only person on the scene besides myself.
Okay. Now, based upon your observations of the defendant's vehicle, did you come to any conclusions?
Yes, for somebody to fail to maintain lane and strike a fixed object, you have to be under some kind of influence. Of course, a single car accident.
Okay, and did there come a time when you actually placed Alicia Story under arrest?
Yes,
Okay, and did this accident occur in Fulton County?
yes, it did.
Okay, and it was in the city of Atlanta, is that correct?
Yes, it was.
Okay, now, did you ask the defendant to perform any type of field sobriety evaluations?
I don't believe I did because she admitted for the breath test. And the way she was swearing, I really should have even finished the field sobriety exercise.
I'm gonna ask if you could just slow down and take that step by step. Do you need the officer to actually turn around a bit?
I mean, that if he would, that would be great.
Okay.
That I appreciate.
All right, officer, if you could just position yourself so that defense counsel can see you and the judge.
I'm good. Just
The
look
judge
at
is fine.
Mr.
Okay.
Taylor.
All right. Now, did you, I'm gonna re-ask the question. Did you ask the defendant to perform any field sobriety evaluations?
No, I did not.
I'm sorry.
No, I did not.
Okay, and why was that?
Because when I was observing her, she was intoxicated, swaying from side to side, and she already agreed to do a breath test.
Okay, when you said she agreed to do a breath test, what do you mean?
Well, she requested one before I even asked.
Or you asked her, the defendant requested a breath test?
Yes,
Okay, and did there come a time when you were actually able to provide a breath test?
yes, there was.
Okay, please tell the court where this breath test occurred.
The breath test took place at City of Atlanta Jail, where the detention officer, he was certified to use the machine, and I was not. So he performed the breath test, and I observed it.
Okay, let me take you back. After the defendant made the after the defendant made the statement that she wanted to have a breath test, what exactly did you do?
She was placed on arrest. I also read Georgia Impact Consent Notice.
Okay,
So I was over 21.
okay, and how did you ascertain that she was over 21?
With that driver's license.
Okay, and did you read any other warnings?
I believe I read her Miranda rights,
Okay, and why did you do that?
because she's asking for a breath test. I want to make sure that she knows the rights.
Okay, and do you normally read Miranda rights during a DUI investigation?
No, just Georgia Impact Consent.
Okay, and so what made this particular case different for you to do that?
Well, it's an accident, and she's just offering to do a test. So I'll make sure that she knows the rights.
Okay, and you felt that it was safer that you read her Miranda rights and the Georgia implied consent?
Yes.
And do you have that Georgia implied consent with you?
Yes, I do.
Okay, I'd like to introduce that into evidence. Do you have, or at least mark it for identification? Thank you. Your Honor, how,
You can show it to Mr. Taylor and then we'll mark that as
we don't need the
State's Exhibit 1. Yes.
so for those purposes,
Can I just give you the top page? Because the rest is
you want to cut that off?
Yeah.
For these purposes, we will consider this marked as State's Exhibit 1 for identification.
Your Honor, I would object at this point. It appears to be some type of computer printout or something, as opposed to of his actual card. And without the proper foundation, I don't think that would be admissible.
All right. Ms. Marshall Story, do you have a response?
Yes, Your Honor. May I ask the officer a few more questions?
You may.
Okay, Officer Richardson, is this your actual implied consent card?
Yes, it is.
Okay, and how did you obtain that card?
I was given to me at the academy.
Okay, and you carry that card around with you?
Yes, I've been having, look at the paper, I've been having it for many years.
Okay, and so, Your Honor, for those reasons, we believe that this is properly authenticated, and we'd ask that it be moved into evidence.
Any further objection?
Actual card.
Any further objection?
Judge, if he's testifying that is what he read to her, we don't have an objection.
All right. Objection withdrawn. Next question.
Thank you. And that is the paperwork that you read to this story, is that correct?
Yes.
Okay, and Your Honor, we'd like to read that implied consent into the record.
You may.
Okay, if you could please read that. The
And
object, what has been marked as State's Exhibit.
again, Judge,
one.
I'm sorry.
What?
Your Honor, this is cumulative. It's what he testified to a moment ago was that he read that into the record, or excuse me, that's what he read to her. And so now him reading it is just, there's no point.
All right.
As long as you're willing to stipulate that it is properly in the record, that's fine.
I'll stipulate that he testifies right now that he read that to her. I won't stipulate that he actually did read it to her. He just testified that he read it, but I can't stipulate that he in fact did read that to her.
I don't see the distinction. So if you're not going to have him read what he allegedly read to her in that document on the night in question, on the day in question, then we're going to move on to the next question. The issue of whether the defendant was given her implied consent notice rights, that's going to be a matter for me to decide. But based on what you're telling me, I'm moving on to the next question.
Okay, thank you, Judge.
Thank you. Ms. Marshall Stewart?
Thank you, Your Honor. Do you feel, based upon your training and experience, that the defendant understood what was read to her?
Yes,
Objection, speculation.
Sustained.
Based upon your training and experience, or actually strike that, based upon your actual observations, did the defendant have any questions about the implied consent that was read to her?
no, she did not.
Okay, did you threaten the defendant in any way to take this test or
No.
take the intoxicator test?
No, I did not.
Okay, and do you feel like you were hostile to her in any way to elicit the statement that I've been drinking?
No, I did not.
Do you recall where the defendant said she had been drinking?
Yes, I did.
Okay, and where was that?
Claremont Lounge.
The Fairmont Lounge. Did she indicate what she had been drinking?
Yes, she did.
And what was that?
Things of rum and coke.
Did the defendant seem frightened to you in any way?
No, she was not.
Did you have an opportunity to ascertain whether or not the victim had suffered any injury as a result of striking this fixed object?
Policy states that when you get in an auto accident, you take down the driver to Grady. But policy states, SOP states that once somebody's in an accident and they're being arrested, you take them to Grady. But during that incident, the driver had no form of physical injuries that I observed.
Okay. Did Ms. Story indicate that she needed to go to Grady?
No, she did not.
Okay, and was there an ambulance on the scene?
No, there was not.
Okay. Now, let me go back for a few seconds. Did you have a dash cam or body cam that was activated or working on the date of the incident?
Yes, I had my body camera on.
Okay, and can you just explain to the court what a body camera is and how the Atlanta Police Department uses the body?
Okay, so a little device that goes right above the chest where I have this plate. And from the time you get dispatched to call, you have to activate it. So when you arrive on the scene, it will already be recorded. And which recorded all my actions from the time I arrived to the time I finished with the call with whoever I interact with.
Okay, just one second, please, Your Honor. Okay, with the court's indulgence, I would like to show the officer these two videos. Do you recognize not so much the video, but the indication of what is written on here?
What the numbers, the last, was it 3 or 4, look like the case number that's inside there.
Okay, and do you see a name on that video that you recognize?
Recognize the last name, Story.
Your Honor, may I just have a second? I was hoping to have the table that I need to look
I
at.
understood.
Your Honor, we can certainly slide down if you'd like, and she can move her stuff right here, and Miss Story, she can sit in there, and I'll move over just to make it easier if you want.
I'm not gonna have folks moving right now.
Okay.
Just a notice to everyone, I have a 1:30 bench trial calendar. If I don't reach all the motions, they're gonna be reset. So if y'all have conferred with the police officers and you're still confident you want to move forward with the hearing, that's fine. But 1:30, I'm cutting it off and I'm going to do my bench trials. If I don't have any bench trials, we'll move on with motion. All right? Okay. Ms. McCutcheon, are you going to play any of those videos?
Yes, I would like to do that, Your
How
Honor.
much time would it take for each video?
There are 2 videos and they are probably about 40 minutes.
Okay, that's not going to happen.
Okay.
Mr. Taylor, have you seen the videos?
Judge, I was provided with one video. And so I've seen one, and it goes from the scene to.
This is a probable cause hearing, guys. I'm not having a trial within a trial. So if there is anything else that you want, that you believe has not established probable cause?
No, the the state would like to have these marked for identification and placed into evidence in case the court is in need of them to issue a ruling.
They've only seen one video. Which video did they see from the exhibits that you presented?
Your Honor, I sent everything via evidence.com. And so I don't know if it's the way
They
that
may
our
have,
office.
they may have put both videos on one disc. So what I'm saying is that I was given one, she's got two, it may be divided up. I think I've seen everything.
Okay, all right. Now, folks, remember, this is a motion in limine, a motion to suppress. The issue is probable cause. The issue is not beyond a reasonable doubt.
Right.
So I'm not gonna go for a blow by blow account of the entire incident, okay?
It does show the defendant on the scene, and I thought that may be relevant, but I do believe that we have properly established that the defendant was arrested and that there was probable cause for the arrest. But I would like to have these marked into evidence.
Any objection?
I don't have objection to those videos, Judge, but I will say that we are also arguing implied consent as well. There is a dispute as to whether or not he read the full implied consent, and that's only going to be seen on the video. So I think it is critical to this proceeding, which I suppose is where she was going.
I'm not gonna go there. If I find probable cause, we're gonna go to trial.
But
You
but
can
Judge,
question him on what you read and where you find deficiencies. That's where we're gonna go.
Your Honor, if I may, we have a right to file the motion to suppress the results of the breath test,
Mhm.
which we have done. And we believe that it is critical to you seeing all of the relevant evidence to see the video wherein what I was given, he doesn't actually read the full implied consent. That is a pretrial motion, which is critical and is best.
You've seen the exhibit that he claims to have read it, and I've already asked you whether you want him to read that exhibit. You said no.
Right.
So you can cross-examine him on that. That's
Are you
all-
saying I can't
that's all
play
I'm-
video?
Yeah,
I can't show the video?
that's right. All right.
Judge,
next.
that's critical evidence. That's
Mr. Taylor, moving on. Next question.
Your Honor, Officer Richardson, after you made the arrest of the defendant, did you place her inside of your vehicle?
Yes, I did.
And where did you transport her after that?
First, we went to City of Atlanta Jail, where the correction officer performed the breath test.
Okay, all right, Your Honor, no further questions.
All right. Cross-examination?
this arrest occurred, I'm gonna move up here. You okay with that? Okay. Cool. This arrest occurred back in 2018, is that right?
2019.
2000, okay. So roughly 3 years ago? And you've had DUI training since that arrest until the present day, right?
Yes.
Okay. And you've made DUI arrests since Miss Story was arrested until the present day, right?
Yes.
So when you say you've had 11 years of experience, at the time of her arrest, you had only had about 8 years of experience, right?
Yes.
Okay. Have you taken any refresher courses since the point of the arrest until today on DUI and field sobriety evaluations?
Yes, I have.
Okay. All right. Now, you will agree that on the date of the arrest, after you initially confronted Miss Story, you had to get back into your patrol vehicle and you had to call a supervisor to ask that supervisor what you should do next. Isn't that right?
Not pertaining to the DUI because I had to read the Miranda rights.
Okay. So you talked to a supervisor about whether, and I'm speaking loud so it's clear because it's, so please don't take it personally.
No,
You spoke with the supervisor about what you were supposed to do next.
in terms of Miranda.
Okay.
Yes.
And you agree that you read her the Miranda rights.
Yes.
And then you began to read her the implied consent right. Isn't that correct?
Yes.
You will also agree that you only read the first sentence of the implied consent right. Isn't that correct?
No.
It's your testimony today that you read the entire advisement.
Well, it happened 3 years ago. Most likely I did.
Well, and I understand.
Yes, I need to look
I
at the
understand. I'm asking you what you did. Do you recall reading her the entire advisement?
I read the Miranda rights.
Okay. Did you read her the entire implied consent advisement?
I can't recall.
Judge, that's why we need the video.
You do not recall if you read her the implied consent, right?
Judges, this is something I do every day,
Mhm.
and if I'm not 100% sure, I'm not gonna say yes.
All right. And do we have the video of the incident?
Your Honor, can we approach, please?
Well, I'm gonna take this under advisement and watch the video and then issue a ruling. So,
Well, this may assist. Can we approach?
no, yeah, go ahead.
Yes.
I figured that was a field supervisor. Yeah,
The other witnesses for one.
the field supervisor, excuse me, the topsilizer test. They don't have the witness. to-
Excuse me, Your Honor. This is the court reporter. I'm not hearing anything right now. After the bench conference, I wasn't hearing anything.
Sorry, I just had a sidebar, so we're good now. Sorry about that. Thank you for
Okay,
letting me
thank
know.
you.
Thank
Thank
you.
you.
All right, Mr. Taylor, this is, all right, go ahead.
Okay, so in your training, as it relates to individuals exhibiting symptoms of impairment, you have been informed that an individual being involved in a car accident could cause head trauma, right?
Possibly.
Yes. And when you have head trauma or other injuries, it's possible that you could exhibit symptoms such as instability on feet, right?
Well, I'm not a medical unit, but
Yeah.
from my experience, which is very rare, sometimes it do occur.
Which is what?
Sometimes it do occur, which is very rare.
Okay. So you'll agree then that sometimes when an individual is in a car wreck, they get banged around a little bit and it jostles them, right? Okay. And they may not be as steady on their feet as they normally are, right?
Correct.
Okay. She was involved in a car wreck, right?
Yes.
All right. And it was a car wreck to such a degree that your policy said you had to take her to the hospital, right?
No, any accident.
Okay.
It doesn't matter if it's
Sure.
a fender bender.
Right.
Any accident.
So anytime if somebody is in a car wreck, your departmental policy says we need to get them checked out because there may be an issue.
Especially, well, if they're going to jail.
Okay.
Yeah.
All right. So you had never had an opportunity to speak with her prior to that night?
No.
Okay. And so you really don't have a baseline of what her manner of speech is to determine whether or not it sounded slurred that night or whether or not that's just what Alicia sounds like. Isn't that correct?
Well, speaking to someone, you can tell if it's fluent or when you stuttering, you're being slurred because I've been doing this for a while.
Okay.
So her
So-
speech was not fluent.
It wasn't fluent?
No.
Have people ever had a hard time hearing what you're saying?
Yes.
All right. And you're not intoxicated all the time.
I'm definitely
No,
not intoxicated.
okay, all right.
Okay.
So it's possible that sometimes individuals have a manner of speech that may sound like they are under the influence, but they simply may not be. It just may be the way that they sound.
It's a possibility. Yes.
Okay, thank you. And do you recall had the airbags deployed?
I can't recall.
Okay.
Okay.
You know, though, that when airbags deploy, there's a whole bunch of dust and somebody gets hit in the face. Isn't that right?
Yes,
And that can cause the eyes to water, can it?
I have no idea on that.
Okay, somebody gets hit in the face, it can cause eyes to water, correct?
Your Honor, objection, the question has been asked.
Sustained. Next question.
I was trying to hear what she was saying and I didn't catch what you said.
I heard what she said, and she said the question's been asked and answered, and I agree with her.
Okay.
Sustained.
All
Next
right.
question.
So you don't know what her normal manner of speech is. An individual who has been involved in a car wreck can sometimes be unstable on their feet. And in this particular instance, both of those two things are present, right?
Yes,
Okay, all right. Now, did you offer her a portable breath test there on the side of the road?
we don't have,
You didn't have it, or your department doesn't have it?
the only people that have it is you on the specialized unit, which is a DUI. That's
Uh-huh.
all they do.
Okay, did you call that unit over?
There's no need to do it. Because once a person intoxicated under arrest, you take them to the jail to
Right.
perform it.
So why didn't you have her blow into the portable breath testing machine before you arrested her?
We don't have it
Well, why didn't you call the people?
because we don't have it. That's what I'm saying. The only people that have it and they work certain hours and stuff. But if you have an arrest with a DUI,
Yeah.
you either take them to the civil and the jail once the machine is working. If not, we go down to maybe Georgia State and use theirs.
Okay, all right.
Yeah.
Why didn't you conduct the HGN on her?
At that point in time, I was not trained on that.
Okay, why didn't you do the one leg stand on her?
She's intoxicated from seeing her movements. She will not pass it, and she also agreed to do the breath test.
Okay. Why didn't you do the one, did I say one leg stand?
Yeah.
Why didn't you do the walk and turn?
She's intoxicated. She will not be able to pass it. You can see from her walking back and forth.
Okay,
And she also volunteered again to do the breath test.
okay, all right. So you didn't think she was going to pass the test is why you didn't administer it.
Exactly.
All right. Okay. How many officers were at the scene?
I want to say just me, but I'm not sure.
Okay. Do you recall if you called anybody for backup?
No, she wasn't giving me any problems, so I doubt I might call, but sometimes you might be there and somebody just passed by to make sure you.
And so she was cooperative.
Yeah, she wasn't giving me a hard time.
Okay.
She was just asking like to speak to her husband or. She just wasn't giving me any problems to where I would have to use force or, you know,
Okay.
yeah.
Did she use her telephone to call anybody?
I remember her like saying she wanted to speak to her husband. I can't recall if she used her phone to call somebody.
Okay. So do you recall her being able to talk with anybody at the scene other than you?
Yeah, I think I'm the only person she talked to. You can't quote me.
Could you speak up, officer? I'm sorry.
I can't recall if she spoke to somebody else,
Okay.
but I know she was asking to speak to her husband.
Okay. Do you know why?
Your Honor,
No,
objection.
I have no
Is there any
idea why.
relevance to this line of questioning?
Yes, Judge, if I may respond.
Yes.
Judge, it is relevant because it isn't fair to just pick out the things that could be indicative of impairment. If we're able to have the officer testify today to the fact that she was aware of the nature of the relationships of the people at the scene, the reasonableness of the conversations, her ability to manipulate the telephone keys with her fine motor skills, those are all important things to get the entire picture about how an individual was on the side of the road.
I'm on a probable cause stage. Objection sustained. Next question.
Well, we believe that is probable cause, Judge.
Objection noted.
Okay, thank you. All right, so you eventually put her in handcuffs, is that right?
Yes,
And then you put her in the back of your car?
yes.
All right, did she fight you at any point?
No,
Did she throw up?
that I can recall.
All right, did she fall down?
No.
Did you have to guide her into the vehicle?
Well, when you arrest somebody and you put them in handcuffs, you make sure to have some form of physical contact with that person.
All right, so any kind of physical contact you had with her was not to prop her up, it was just to make sure she doesn't run away and she gets into the car safely, right?
Yes,
And even though you did that, even though there was no indication she was trying to run away.
no, that's how.
Okay.
That's how you train, to make sure to have some form of body contact with that person.
And she was compliant in the back of the car?
Yeah, she was compliant. There's
Did
a
y'all
better-
have any conversations?
I can't recall.
All right. Okay. She wasn't screaming in hysterics 1 minute and then laughing the next, was she?
No, not that I can recall.
Her emotions were pretty level, right?
I would say so, yes.
And when you asked a question, she gave you an answer that made sense to that question, right?
Well, she would answer me before I even asked the question, like she would constantly say she wanted a breath test.
Okay, well, give me another example of how she answered you before you asked a question.
She would tell me what she had to drink and where she was coming from.
Okay, give me another example.
I can't recall another one right now.
Objection, the appropriate question would be, is there another example? Council is indicating that this particular witness may or may not have something more to add when he just asked that question.
Is there another example?
Officer, do you recall any further examples?
No, Judge.
Next question.
Okay.
Objection sustained.
All right, so you got to the hospital?
Yes.
All right. And did any other officers appear?
I believe they were detention officers. Because it's like when you go to Grady, you check them in, and the detention officers take over there. And the doctor come and look at them. But there's other officers who might have somebody that they arrest also down there.
Okay, and she was polite and respectful to the officers.
Like I said, during the whole incident, I didn't really have any problem with her per se.
Okay. All right. And so how long were y'all at the hospital?
That I can't recall. I know you go to Grady, you were there for, yeah, you can be there for a while.
Do you recall if she was unable to keep her balance in the hallways or elevator?
No, when you go to Grady detention, you check them in. As soon as you walk in, they put them to sit down. They do what the medical unit do, and you take them to the back in detention. If they have an officer there, you just release them, you check them in, and you leave.
Right. And she was able to follow their instructions?
I wasn't there. If she's giving them instructions, I'm not there. Most of the time, we just put her on the bed, handcuff her. I do my paperwork. If she has any property, they give it to me. I check it in, and I release custody to them.
Okay, so then after you took possession of her again and you were bringing her to the jail, let's focus on that point in time. Did you have to prevent her from falling or anything like that?
Well, like I said, we are trained to always keep some form of contact on the person. So even said she was supposed to sway, she wouldn't, because I have some form of body contact on her.
Okay, so you don't have, because of your procedures, you don't have any evidence indicating that she was about to fall over, because you prevent that in every case by virtue of having contact with them, right?
The only time I didn't do that was when I arrived on the scene.
Okay, right after the car wreck.
Yeah, when I was dispatched in.
Okay. All right. And how long was it before the end of the car wreck, or excuse me, strike that. How long was it from when the car wreck ended to you arriving on the scene?
Well, I don't know what time she got the incident. I would know the time I got dispatched.
Yeah.
And from the time I got dispatched to the time I arrived.
So you can't tell us how soon after the driving had ended that you came into contact with her? Yes,
I wouldn't know that. It's like whoever called it in, I don't know what time they call it in. What I would do is like, let's say you call now, you call now on, I'm getting dispatched now. I can tell you the time I got dispatched to the time I arrived.
Yeah. And you don't know here today the time frame between the collision happening and the person who called it in. You don't know that.
I won't know that.
You got no idea.
Yeah, I won't know.
Okay. And you don't know if she left the scene.
I don't know.
Okay. So it's possible that after the wreck, she went somewhere and then came back, right? Because you don't know the time frame.
Well, on that,
and I don't want you to guess. I'm asking you. You don't know that, right?
No, I don't know the time frame on that.
Okay. All right. Nothing further, Judge.
Thank you. Any redirect to Ms. Marshall-Story? All right, thank you.
Oh, may I?
Okay. Ms. Greenhouse, if you have a problem hearing, just chime in, okay?
Your Honor, one one additional question. I understand that you were not able to specify, but do you have an idea of how much time may have elapsed?
Objection foundation.
Overruled. And could you clarify the question? What do you mean by lapse? Lapse between,
Lapse between the actual calling in of the incident and the defendant going to Grady?
From the time I arrived to the time I took it to Grady,
Yes. You have an idea?
it's going within the whole incident took maybe about maybe an hour.
So would it be fair to say nothing over 3 hours?
Oh, no.
Okay. Nothing further.
all right, thank you. Any other witnesses from the state?
No, Your Honor. At
Mr.
this time, the state
I
rests.
had one last question.
No. Mr. Taylor, do you have any other witnesses?
No, I don't, Judge, but she had the opportunity to.
Yeah,
redirect,
it's
so I
called
should have my-
direct, cross, redirect. End of story.
No question.
Do you have any other witnesses, sir?
I do not, Judge.
Okay.
Just,
thank you.
just the video, but I don't know if we're even gonna have you look at that now that she conceded that argument.
They have decided to null cross the DUI per se charge, and they're going to proceed on the DUI less say,
That is correct.
in addition to the other charges.
Yeah, in addition
So-
to the failure to report striking an object, too fast for road conditions, and the expired registration.
All right, so this is a motion to suppress the motion of lack of probable cause for the DUI, and so I'm going to keep the record open if you want me to watch the video with regards to the portion of where the implied consent was or was not read.
I don't think that would be an issue though, Judge, because she conceded that count. So that's off the table.
Okay,
Um,
so argument then? Mr. Taylor?
Judge, we were here primarily for the implied consent issue, so the rest of it was just whatever. So now we just submitted on the facts.
All right,
Your Honor, briefly, we would ask the court look at the totality of the circumstances in determining probable cause. The officer has testified to having been called to the scene as a result of a one-car accident. The officer also testified that unelicited, the defendant stated, "I've been drinking," stated where she had been drinking and what she had been drinking. Based upon the accident, based upon the defendant's statements, the state believes that under the totality of the circumstances, or even simply based upon the defendant's own statements, that we have met our burden of probable cause in this matter.
all right, thank
And
you.
with the proper arrest.
All right. As the defense has agreed that the court does not need to review the video with regards to any implied consent issues or with any regards to any issues DUI per se. And also in light of the fact that the state's going to null cross the DUI per se, the court finds sufficient probable cause for the case to move forward to the trial of fact to determine whether there is sufficient evidence to establish beyond a reasonable doubt that the defendant may face charges of failure to maintain lane or improper lane change, reckless driving, driving under the influence of alcohol less safe, and failure to report striking a fixed object. So confused. All right, thank you. Mr. Taylor, if your client would want a bench trial or a jury trial, is she prepared to announce that today, or do you want to announce it another time?
Judge, she would like to have a jury trial in the
Okay.
case.
Mhm.
And anticipate that we're gonna want the transcript.
Okay,
So I don't know if that impacts scheduling. Some jurisdictions it does, some it doesn't.
all right. I don't think it's going to impact scheduling. You'll need to get in touch with Miss Susan Greenhouse. She's the court reporter for this particular matter. All right, this case is concluded. Thank you, Officer Richardson. You're free to go.
Thank you, Judge.
All right, the next case I'm going to address.
I apologize, Judge. Don't want to interrupt you. I don't believe I actually had another case on this calendar. Wanted to make sure I was excused, though.
Yes, Miss Helen, thank you very much.
Thank you, Judge.
All right, now, before I move on to the next case, logistically speaking, do the defense and the prosecution and counsel want to move tables so they're more comfortable? Ms. McCutcheon, is your case up next?
I'm sorry, Your Honor.
You have Simpkins
Yes, that's Ms. Marshall's story, but I'll handle it. Let Ms. Marshall's story is ready.
Okay,
There's
Yeah.
three on that case, Your Honor. I just need to fill out the paperwork.
I'm sorry, repeat.
There are three on that case.
Okay, so
In order, do paperwork.
understood, okay. Trooper Gianalis, does he need to remain in the courtroom? Ms. McCutcheon, does the trooper need to remain in the courtroom?
He's already left.
Oh, he's already left, okay, good, all right. So then we will move on to. What's the other case? Mr. Sullivan, you ready? All right, so logistically speaking, there was a recommendation that prosecution moved this way and the defense moved that way. Boy, it's just logistically, I mean, just physical locations. Are y'all comfortable? It was very awkward.
I'm fine if the court wants us to.
Y'all comfortable?
Fine, Judge. I'm with all of
All right, Mr. Sullivan and Mr. McGee have a seat at that table.
I got the gist of Mr. Taylor is here, so I'm fine with it.
I'm sorry, you know, it's only been since 2006 that I've been asking for those doors to be removed. And are we going to keep both the officers in the courtroom? Or do you need both officers to testify or one of them? Miss Marshall Story, do you need both officers or one of them? Or Mr. McCutcheon?
It's my case.
All right,
You need both of them, so are you invoking the rule?
Yes.
all right. Who are we going to call first?
State the call of officer, Mike. And Officer Hope, you would just step outside, please, sir. And actually, Officer Mike, if you'll hand that to me, and I'll get that to you.
All right, so Miss McCutcheon, officer, just hold please. Hold. Outside this courtroom is a big screen
Oh.
that broadcasts this Zoom. I don't know if it's at that end, so officer, if you would, there's a bench on the other end in front of courtroom G40. I'm just going to ask you to exercise the honor code and not pay attention to the screen, okay? Thank you.
Judge, I completely forgot, you're right, the restoration issue. You're right, this is the state versus John McGee, and it is.
Excuse me, Your Honor, as the court reporter, I'm having a little trouble hearing the solicitor.
Tap on the mic and see. It should be a green light there. I tell you what, Ms. McCutcheon, why don't you go up to that microphone? Because I do know that works.
Okay, thank you.
Okay.
This is state versus John McGee, case 20CR003727F. Defendant is charged with driving under the influence of alcohol, less safe, reckless driving, hit and run, failure to maintain lane, or improper lane change. Counsel for the defendant, judge, just for a roadmap, has filed multiple motions, a waiver, a plea of not guilty, and waiver, and a waiver of arraignment, a plea of not guilty, and request of jury trial demand. Discovery motion and Brady motions, to which the state has complied. As far as the motion before the court today, counsel, the state's roadmap would show as follows. There's a motion to suppress the HGN, which the state would submit to the court is not applicable because there was no HGN test administered in this case.
That's correct, Judge. We'll withdraw
Oh, let me just then ask Mr. Sullivan, what other items remain to be addressed in your motion to suppress? Because that you have a whole list. So I just
Okay.
need to know what are we going to address within the next 40 minutes.
Yes, Judge. We have a probable cause motion. We do have a motion to suppress statements acts motion. That's basically a Miranda motion. Any statements that Mr. McGahee made post custody, we're asking to be excluded. We do have I'm not sure whether the state's conceding this, implied consent refusal Are you contending that the refusal to submit to the chemical test is admissible or not?
Well, Judge, that's what the state was going to lay out for the court, those motions that the state felt were applicable and were not. Council did file a motion regarding the refusal to submit to the chemical test and the breath test. This was a refusal. It was a 2008, it's a 2018 case. So of course, according to the case law, the state would be unable to admit any evidence of the refusal at trial.
Your Honor, after that, we do have, it appears that there's an attempt to administer a field sobriety to Mr. McGehee, to which he subsequently refused. We do have a motion on that under basically Elliott, Georgia constitutional grounds to exclude any mention of his election not to perform field sobriety evaluations.
Ms. McCutcheon?
Judge, we'll go forward on that because the state is opposed to the court granting that motion in regard to the walk and turn. In regard to council's motion regarding suppression of the one leg stand, that is not applicable. There was no one leg stand administered in this case.
Okay.
So would you withdraw that motion then regarding the HGN and the one leg stand, council?
Well, for that part of the motion, yes.
Yes.
All right. So we will just proceed with the walk and turn. Next.
Judge, I believe that covers our motion.
All right. So it's the motion with regards to trying to suppress any post Miranda statements.
Yes, Judge.
All right. Regarding the walk and turn. And I wasn't certain where we were going with this. The attempt to administer field sobriety test.
He was essentially refusing to do field sobriety. We're seeking to exclude that refusal from trial under Elliott, Georgia constitutional grounds.
All right.
MTC, of course.
Any, for purposes of probable cause, any reason why we should explore the refusal to admit, to agree to do field
No,
sobriety?
Judge, as I said, the state would agree that the refusal
Okay.
to the test is.
So I don't think that's an issue right now for purposes of probable cause.
Yes, Your Honor. Okay.
All right. Okay.
Oh, Your Honor, there was a motion, council had a motion to exclude the officer's testimony regarding field sobriety test as scientific test. And he conceded that the HGN is the only scientific test. That is not applicable here because there is no HGN, and the state agrees that the one leg stand, which the walk and turn, which we anticipate the officer will testify to, is not a scientific test and would be admissible.
Are we going to go on to the walk and turn to be excluded as a scientific test?
No, Judge.
All right, so that's not an issue. Anything else on the roadmap you wanted to scratch out, Ms. McCutcheon?
No, Judge, I believe as far as the roadmap, we are ready to proceed.
All right.
And so-
Officer, if you please raise your right hand, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Thank you, sir. And what's your full name?
Rodney Smither,
And Mr. Smither, you are with?
City of Atlanta Police Department.
Thank you.
And Officer Smithers, how are you a post-certified law enforcement officer?
Yes, I am.
And have you completed all of your peace officer standard training?
Yes, I have.
And how long have you been employed with the Atlanta Police Department?
Since September of 2011.
And prior to your employment with the Atlanta Police Department, were you employed with any other law enforcement agency?
No.
And let's take you back to 2018, specifically on the date of this case, this incident, August the 3rd, 2018. Were you working with the Atlanta Police Department on that date?
Yes.
And were you
You would need to speak up, Ms. McCutcheon, because you need to, thank you.
working in uniform and in a marked patrol vehicle?
Yes, I was.
Uniform similar to the uniform that you're wearing today in court?
No, I believe it was a different, I believe I was wearing a mesh vest uniform identifying myself as a police officer.
And does it have the same identifying insignia similar to what you're wearing today, identifying you as a law enforcement officer? With
Yes, it had the City of Atlanta department patch, the word police across it, and my name tag.
And did you come into contact with a suspect later identified by the name of John McGee?
No, I don't believe I ever saw him. I know he was in the ambulance. I don't think I ever saw him.
Did you ever respond to a location where there had been a report of a driver having been involved in some collisions?
Yes.
And do you remember to what location you responded?
In the Morningside neighborhood of the city of Atlanta, the specific streets, there were a couple, I can't remember the specifics of which street which were.
If I hand you the report, would that help you to refresh your recollection as to what occurred in this case?
Yes,
And let me ask you, was there also another officer involved in the investigation in this matter?
yes.
And what is the name of that officer?
Officer Ho?
And did both yourself and Officer Ho complete reports for the Atlanta Police Department?
Yes,
And are you required to complete investigative reports summarizing your involvement in a case investigation?
yes,
And are these reports maintained within the Atlanta Police Department as regular records from the regular course of business?
yes.
I am handing you what I'm going to mark for identification as State's Exhibit number 1. And if you can tell me if you can identify this exhibit. And if you would look at the very last 2 pages. Let me show it to council. It's been previously provided in discovery, but I want to show it to council. State's Exhibit number 1, and I'm going to draw your attention specifically to the last 2 pages. Previously provided to council and discovery. Do you recognize the exhibit first off, Mr. Officer Myers?
Yes.
And what is that?
It's the police report that I wrote documenting my involvement.
And I'm looking at that report. What is the exact location to which you responded?
We responded to the intersection of Cumberland Road and Lexington Road.
And Cumberland Road and Lexington Road, is that located within Fulton County?
Yes.
And explain to the court, if you would, why you were called to respond to that location.
We were called to respond to a single vehicle accident that also had struck several items in that neighborhood.
And explain what occurred during the single car accident based on what you observed when you arrived at the location.
I believe from my investigation, we found that it had struck a vehicle a couple blocks away. Also some road fixtures, the curb, and a mailbox, maybe a sign as well before it got stuck on the driveway, I think.
Now, this one car accident, this car that was struck, was this car attended to or occupied by any person or persons?
The part that I investigated, the car that was struck, it wasn't occupied. It was I believe it was a woman who was putting her infant child inside the vehicle before she had to jump into the vehicle to avoid being struck.
So are you testifying, is it your testimony, Officer Smithers, that the vehicle was not occupied, but it was attended to by a person putting her child into the car?
Being attended to, yes.
And were you able to identify visual damage to that vehicle?
Yes.
And you also testified that there were other objects that had been struck. Were those on the same roadway or in the same area as the vehicle that was struck when the mother and her child were attempting to get into the vehicle?
Yes, same area along the same road. That neighborhood kind of has a bunch of streets, changed names and stuff, so I can't remember the exact street names, but yes, same area. I believe I walked from one spot to the other.
And you said walk from one spot. Are you referring to the spot where the car was struck and then the spot where the other items that you testified to were struck?
Yes, they were within walking distance.
Is this a residential or commercial area?
Residential.
And do you recall what time of day this was, Officer Smithers?
I believe it was early afternoon or mid-afternoon.
Does your report indicate a time?
It should, yes.
And what time is indicated? If you look at the next to the last page of your report.
It says that it began at 3:19 in the afternoon.
And looking at that same page of your report, did you ever come into contact with the suspected driver of the vehicle involved in the collision?
No.
Did you ever come into contact with the vehicle itself?
His vehicle that he was driving? Yes, I did.
And during the course of the investigation with yourself and Officer Ho, did you ever learn the identity of the person who was suspected to have been driving that vehicle?
Yes.
And what was that person's name?
John McGehee.
And did you ever yourself do any search or inventory of that vehicle?
I don't believe I entered the truck and did a proper documented inventory, but I do recall looking into it and observing items.
And when you, what type of vehicle was it? Do you recall off the title?
It was a pickup.
And when you testified that you looked into the pickup truck, were there any objects that were in plain view, clearly visible to you inside the truck?
Yes.
And what were those items? What was that item or item?
I believe I saw a bottle of vodka within arm's reach, right on the back passenger area in the center, within the arm's reach of the driver's seat.
And did you document in your report that you had observed that bottle of vodka within arm's reach of the driver's seat in the vehicle?
Yes.
He was expected to drive.
Yes.
Did you do anything else in regard to this investigation?
I believe I completed a report involving the vehicle that was struck. Not at the final scene was, but the walking distance from the mother. I documented that, and then I wrote a supplement report for Officer Ho, stating what I heard from witnesses and what I observed on that scene.
And when you spoke with the mother, did the mother give a statement to you without telling us what she said? Did she give a statement to you?
Yes.
And based on the statement that the mother gave to you regarding her and her child at that scene, were you able to draw a connection between Mr. McGee and the mailbox that had been struck, or mailboxes, and that vehicle belonging to the mother?
Yes.
The vehicle that you looked into, that you identified as a pickup truck belonging to, suspected to belong to Mr. McGee, where was that vehicle actually located when you walked from the location you testified where the mother had been, her vehicle had been struck, to where you saw the vehicle?
I believe it was in a driveway or I think it was a driveway.
And did your report indicate how the truck was located in the driveway, or what was the condition of the truck in the driveway?
I believe that it was stuck in the driveway. From what I recall, from what witness stated, he was trying to move it, but wasn't able to get it out of that area where it stopped.
And were there other witnesses in addition to the mother who was attending to her vehicle and her child, other witnesses on the scene that gave information or statements to you?
Yes.
And the information that you received from both the mother, and let me keep saying the mother, do you recall her name?
No.
The information you obtained from the mother and the information you obtained from any other witnesses, was it all consistent with the truck having been the vehicle that caused the collisions with the vehicle and the mailbox?
Yes.
And was the information all consistent with persons having observed the driver of that truck committing the striking of these fixtures and the motor vehicle?
Yes.
Were you present when Officer Ho arrived at the location?
Yes.
And did you and Officer Ho talk about what was going to occur?
Yes.
And are you aware as to what happened with the investigation once you concluded your involvement?
I believe, as far as I know, he was arrested and charged with DUI. So.
And it's your testimony, you never actually saw the suspect identified as the owner of the truck, John McGee?
No, I did not.
The driver of the truck?
No, I don't believe I ever made contact with him.
Were there any other persons outside in that area other than the mother and the witnesses you testified had given information? Do you recall?
Besides the witnesses and the mother, I mean, it's a residential neighborhood. There's lots of people walking around, but no, I don't recall specifically.
Any other persons come up to you and offering any information about what had occurred other than the witnesses who observed the collision, mailboxes, and the mother?
The mother's husband was the one who initially alerted me. I arrived on the scene where the truck had stopped first, and I was alerted by her husband that, you know, down the road she was there, who had called 911 concerning her car being hit by that truck.
Okay. Thank you. I have nothing further. I'll pass the witness.
Mr. Sullivan, do you have any questions to ask about this? It was Smither, right?
Smither.
Smither, excuse me.
Yes, Judge. Officer Smither, the husband on scene, he didn't indicate to you that he was with the mother when the collision occurred?
I don't recall. I don't think he did. No.
Okay. Now, when you spoke to the mother, did she give a description of the vehicle?
I don't recall if she gave a specific description of the vehicle.
Okay. Do you recall whether she gave a description of Mr. McGehee?
No, I don't think she gave a description of the driver.
That's all I have, Judge.
Thank you, Mrs. Solomon.
One question on redirect.
Very brief redirect.
Looking at your report, if you need to refresh your recollection, Officer Smithers, did you indicate in your report whether or not any of the persons who provided information to you indicated that they had seen the male driving the truck? I'll draw your attention to your report if you look at the first paragraph of your report. That next to last page.
In your question, I'm sorry. Your question was.
Do you recall, if you need to refresh your recollection from your report, speaking with any witnesses who gave information that they had observed the driver later identified as John McGehee driving that truck? And I'll draw your attention to line 1, 2, the third line, beginning the third line of your report, Officer Smithers. Judge, if I might approach the witness and just.
Okay. Yeah. Yes.
And my question again, you need me to repeat my question?
Yes, please. I'm sorry.
Yes, okay, I speak quickly, I apologize. Looking at your report to refresh your recollection, did any witnesses identify John McGee, the suspect later identified as John McGee, as the person they observed driving the truck?
Yes.
That hit the mailbox at that location?
Yes.
All right, thank you.
All right. Officer Smithers is going to remain in the courtroom. I'm not going to exclude him from the courtroom. He's not going to be subject to being recalled. Officer Smithers, you're welcome.
I'll take that, yes.
Miss Riley, Miss Riley, right? Yeah, okay. Could you please call, Gideon, sorry. Could you please summon Officer Hope? Is that Officer Hope?
Officer Ho is the one that was.
Okay.
Yes.
I'm just going to take a pause, Miss Greenhouse, in this particular hearing. Miss, sorry, Donnelly, are you ready with your plea?
Yes, we are.
Who's taking the plea for Miss Marshall's story? Yeah. Do you have the paperwork already, all signed off? Sent? Okay. Mr. Taylor, did you have anything else to address to the court?
Not to the court, Judge. I like watching Mr. Sullivan. He's a great attorney, and Miss McCutcheon, she's a great attorney as well.
All right. So, Ms. Greenhouse, we're just going to take a pause. We're going to take a plea so that folks who just have to speak and then leave. This is case number 20 CR 002260F. State versus Christopher Ian Simpkins. Mr. Simpkins is present and represented by his attorney, Ms. Donnelly. Is that correct?
Donnelly, but close.
Donnelly. I'm sorry, it's not a name I'm familiar with. So.
It's a,
What may I ask?
It's a check.
Check. Okay, Donnelly. Okay, and Mr. Simpkins is present with you. Excellent. And we have Ms. Marshall Story is representing the Solicitor General's office of Fulton County. Mr. Simpkins was initially accused of DUI, driving under the influence of alcohol less safe, speeding, failure to maintain lane, or improper lane change, and reckless driving. The Solicitor General's office has just submitted a proposed order to null pros the DUI, speeding, failure to maintain lane, or improper lane change charges. So the only matter to be addressed is the one remaining charge of reckless driving. Is that correct, Ms. Donnelly?
That is correct, Your Honor.
Okay. All right. Mr. Simpkins, you have a right to remain silent about the facts of the case. Anything you say about the facts, your statements can and will be used against you. You have a right to an attorney, and you're represented by Ms. Donnelly, whose name I finally pinned down. Okay. This is going to be a negotiated plea, which means that the prosecutor is going to articulate the terms of the recommended sentence. And then your attorney will give me a response, after which I will ask you some questions just to ascertain that your plea is being done knowingly, willingly, and voluntarily. Okay?
Yes, Your
May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your
Thank you. All right, with regards to the remaining charge of reckless driving, what's the state offering?
Your Honor, the state's recommendation on the reckless driving charge is 12 months to serve 24 hours with credit for time served. Balance on probation, a $1,000 fine, 60 hours of community service, the risk reduction program, 1 victim impact panel, alcohol, drug evaluation and treatment if needed, random screening while on probation. However, the state will agree to
Non-reporting?
non-reporting once the conditions are completed. Your Honor, I'd also like to put on the record that Trooper G. Ellis wasn't back in the courtroom, prepared to move forward with the hearing. Ms. McCutcheon was able to speak with him, and the trooper did agree that this would be an appropriate case for reckless driving.
All right, thank you. Ms. Donnelly?
Yes, can I clarify one thing, just because the handwriting looked like 60 hours community service, it's actually 40 hours community service. It's the standard. Yeah.
That's fine.
We will make a note that's an amendment to 40 hours of voluntary community service, okay?
Thank you.
And Ms. Donnelly, are those the terms to which your client has agreed? And do you stipulate the factual basis, venue and ID for the sole remaining charge of reckless driving?
Yes, Your Honor, we do agree to the recommended sentence from the state. The only thing that I wanted to put on the record is that my client lives between Jonesboro and Lovejoy and Clayton County.
Mhm.
I was hoping he could meet with probation today, just if he does have gainful employment and works 9 to 5, Monday through Friday. I don't know how misdemeanor probation can do it here, but if we could either transfer it to Clayton or potentially do mail or phone, just because it's about a 40-minute drive for my client.
It's going to be an inconvenience, at least for the first month. If this plea does move forward, then at least for next week, he would need to report in person. And then I will instruct probation that either they transfer it to Clayton County or he would need to report once a month.
Okay.
All right?
Yes, Your Honor.
Because I don't have the probation officer on Zoom or in the courtroom today.
Okay, so he couldn't report today.
No, we cannot report today. Once we've filled out all the paperwork, they need to be filed and then transmitted to the probation office. And they go through the process of creating the probation files. And between now and then, unless someone from probation is listening to this and willing to come down to G33, I have no guarantee that will happen today.
Yes, Your Honor.
All right. Mr. Simpkins, have you consumed any medication or alcohol recently? And have you understood the proceedings so far?
Yes, Your Honor.
And are you satisfied with the representation of your
Yes, Your
attorney?
Honor.
Is anyone forcing you or inducing you to take a plea today?
No, Your Honor.
And if you decide to enter a guilty plea to reckless driving, you do understand that you would have to give up your constitutional right to have a trial before a judge or a jury. You will not be able to go back to court, confront your accuser, examine witnesses, challenge the state's evidence, present your own defenses if you choose to do so, and have the state try to prove the original have the state try to prove the original charges against you beyond a reasonable doubt. Are you prepared to give up
understand, yes,
these
Your Honor.
rights?
Yes.
And has your attorney explained to you also you have no right to an appeal from a from a sentence pursuant to a plea?
Yes.
And taking such a plea could have an impact on your motor vehicle record, on your license status, on any professional licenses you may have, on your residency status and so forth. All right. And you're doing so freely, knowingly and voluntarily.
Yes.
How are you pleading to one count of reckless driving?
Guilty.
Your sentence is 12 months to serve 24 hours, credit for time served 24 hours. The remainder of the time will be probated. You'll report to probation in person next Thursday at 132 Mitchell Street, where your probation officer will create your probation file. While on probation, you will pay a $1,000 fine plus any court costs and probation fees, complete 40 hours of voluntary community service to be completed at any nonprofit agency, which is not a school and not a religious organization. You'll make sure that the supervisor of the nonprofit agency or agencies provide the necessary letter so that probation is satisfied that you've complied with this condition. You also complete a one risk reduction program, attend one victim impact panel, complete an alcohol and drug evaluation with a healthcare provider, and submit yourself to any treatment if required. You may be subject to random screens for alcohol and or illegal drugs. And once you've completed all the conditions, your probation will be non-reporting. So the sooner you're done with everything, with the exception of random screens, you then would not have to report, and you don't have to pay probation fees. Understood? You may be still subject to random screens, even while you are on non-reporting status. All right, that concludes your sentence. Any questions?
No, Your Honor.
All right, thank you.
Your Honor,
Yes,
this is
Ms.
Ms. James. Yes, I've contacted someone from probation and they're actually coming down. The plea paperwork just needs to be done.
Okay,
If
they're
if
coming
they'll wait a
down.
minute, if they'll
All
just
right,
wait.
thank you.
I
Thank you.
appreciate that.
All right, we got that going. We're going to resume with Officer Hope. Officer, if you please come up to the podium. We're going to resume with the case of State versus Mr. John McGee, 20 CR 003-727F. And the state is going to examine its second witness. Officer, if you could please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do, Your Honor.
And could you please state your full name and your agency?
Tommy Ho, Atlanta Police Department.
All right, and that is with a Y or an I?
Why?
Right, okay, thank you. Ms. McCutcheon?
Yeah.
You may place your hand down, sir.
Good afternoon, Officer Ho. How long have you been employed with the Atlanta Police Department?
Approximately 6 years.
And have you completed all of your police officer standards training?
Yes, I have.
And are you a certified law enforcement officer with arrest powers within the city of Atlanta?
Yes.
And were you employed and on duty with the city of Atlanta on August the 3rd, on or about August the 3rd of 2018?
Yes.
And which division were you assigned to during that time?
Atlanta Police Department, Zone 2, Evening Watch.
And Zone 2, which area is that of the city?
Buckhead area.
And evening watch, what are your hours of, back then, what were your hours of work or duty during evening watch?
I believe it was between 2 p.m. to 10 p.m.
And back then, did you work wearing a uniform and travel in a marked patrol vehicle?
Yes.
And was your uniform similar to the uniform you're wearing now?
No.
Did it also, though it may have been different, was it still a uniform with the insignia and identifying patches, identifying you as a Atlanta Police Department law enforcement officer?
Yes.
And did you come or receive a call to respond to a location involving a collision or collisions in the area of Zone 2 where you patrol?
Yes.
And I'm going to bring your attention specifically to August the 3rd, 2018, involving a suspect by the name of John McGee. Do you recall responding to that investigation?
Yes.
I'm going to hand you what I've marked for previously for identification and shown to defense counsel. It states exhibit number 1. Do you recognize that exhibit, Officer Ho?
Yes.
And what is that, sir?
It is the report for the incident that took place on the collision.
And were you the writer of that report?
Yes.
And was there any other officer that completed a supplement that's included with your case report?
Yes.
And who was that?
That was Officer Smither at the time, but he's currently a sergeant.
Thank you. I did not, was not aware of that. Sergeant Smith is now a sergeant. Thank you for that information on Officer Ho. Are you required by the Atlanta Police Department to complete these reports documenting your investigative efforts and what you did when you responded to a situation?
Yes.
Do you recall the location to which you responded?
Yes.
And what was that location, sir?
Cumberland Road and Wessington Road.
And is that located within Fulton County?
Yes.
And when you arrived at that location, what did you observe?
I observed that John McGee was inside an ambulance. He was getting treatment for one of the Grady EMTs. At some point, he basically refused their services.
And you said refuse EMT services. What do you mean by that?
He did not want any treatment or go down to the hospital.
And why was it that EMT had responded to that location? Do you know, Officer Ho?
Yes, we received a call for a possible intoxicated driver who were basically driving down the road and hit several items inside.
And what is Atlanta Police Department's policy involving suspected DUI drivers who are involved in collision?
So typically when people are involved in collisions like that, people are a little bit too impaired to be driving. And when they go to jail, they have to be medically cleared by going to the hospital. And then before they are booked into Atlanta City Detention Center.
And was Mr. McGehee eventually booked into the Atlanta Detention Center?
Yes,
Were there witnesses at that location when you arrived?
yes,
And without telling us exactly what they said, were those witnesses able to provide you information as to what had occurred?
yes.
Based on the information you received from those witnesses, and do you recall how many witnesses there were, Officer Ho?
There was, I would say, approximately 3 witnesses.
And the 3 witnesses, are you aware of whether any of them sustained any personal injury or property damage as a result of the suspected impaired driver, John McGee?
To my knowledge, no injuries involved, but property damage, yes.
And what type of property damage did we become aware of?
A black GM with side swipe damages.
And were you made aware as to how those side swipe damages occurred?
Yes.
And what did you learn through the course of your investigation, Officer Ho?
Mr. McGee was driving a 2000 black Ford F-150 at the time and basically sideswiped the vehicle, who was loading up her infant child inside her vehicle and almost got ran over. So she hopped over into the vehicle.
And was that witness the mother who was attending her vehicle with her child? Was she present at the scene when you arrived?
Yes,
And you testified that there were other witnesses there. Did the other witnesses provide information to you regarding what they had observed?
yes.
And based on the information they provided, what did you determine had occurred in addition to the mother's vehicle having been sideswiped?
So when I got on scene, I spoke with John Lott, who is a friend of John McGee. He has been friends with him for many years, and he advised John has drank a little bit too much that day.
Objection here, sir.
A response?
I'll rephrase the question. Officer Ho, without telling the court what anyone specifically said, when you spoke to this witness you identified as a close friend, John Lott of Mr. McGehee, did you obtain any information that assisted you in your investigation?
Yes,
Did you obtain any information that was consistent with what you later determined to be your appropriate action as a law enforcement officer?
yes,
In addition to the friend who you spoke with at the scene, the friend of the defendant, did you speak to any other witnesses who had observed the defendant driving?
no,
Are you aware?
The objection sustained, the questions been rephrased.
Oh, thank you. Are you aware as to whether Officer Smithers spoke to any other witnesses who had observed the defendant driving?
yes,
And based on your information received from Officer Smithers during his part of the investigation and your investigation, did you then eventually come into contact with the driver of that vehicle?
yes.
And what type of vehicle was it that was observed by the witnesses who had the vehicle sideswiped and who observed the other activity?
It was a black 2000 black Ford F-150.
And in addition to the vehicle, the mother's vehicle that was sideswiped, what other objects, if any, were struck by the defendant's vehicle?
Mailbox.
And did you observe let's strike that. What is the distance between the mother's vehicle that was struck and the location where you observed the defendant's vehicle?
I would say 2 streets to the east of where the victim's vehicle was.
Was it within walking distance?
Yes,
Is that a residential or a commercial area?
residential.
And when you came upon the defendant, did you ever come upon the defendant's vehicle?
No.
Did you ever observe the defendant's vehicle?
Yes,
When you observed it, was he inside or outside the vehicle?
I believe he was outside.
And did you ever observe the?
I'm sorry, Judge, I didn't hear that.
I
Outside.
didn't hear that either. Okay. Is it
Outside.
outside the vehicle? Okay.
Did you ever observe the defendant driving what you identified was a pickup truck, I believe you testified to?
So, one second.
Did you ever observe the defendant driving the pickup truck you described?
No,
Based on the information that both yourself and Officer Smithers obtained from the witnesses at the scene, were you able to determine whether or not Mr. McGee had been driving that vehicle?
yes,
Were you ever able to make a determination as to whether or not the damage to the mother's vehicle and the mailbox was caused by Mr. McGee driving that pickup truck?
yes.
And where was the pickup truck when you actually saw it?
It was in the driveway of 916 Cumberland Road.
And do you know what condition was it? Ask you that.
It sustained functional damages. You can still drive the pickup truck, but there's a lot of damages to the 12 position as well as the 3 o'clock position. It's sitting on the driver's seat.
And was that damage that you observed to the vehicle consistent with the information that you and your colleague Sergeant Smithers obtained from the witnesses?
Yes,
Were you ever able to run the information on that vehicle to determine to whom that vehicle was registered and who was believed to be the owner of that vehicle?
yes.
And who was that?
John McGee.
And when you encountered Mr. McGee, can you please explain to the court what you observed?
So when I first arrived on scene, I observed that he was getting treatment on the ambulance. And after he refused for their secrecy,
We would have to speak up, Officer Ho.
after he refused services, he went down to the ambulance. And that's when I observed that he had a very staggering walk. He was jumping and he could not maintain his balance. While speaking to him and observing him, he had glassy eyes. And there's a strong odor of alcohol coming from him. And also, Mr. McGee stated that he had a pint of alcohol that day.
And when Mr. McGee stated to you that he had a pint of alcohol that day, was that in response to anything you asked him?
Yes,
And what did you ask him that resulted in him saying he had a pint of alcohol?
if he had anything to drink that day.
And was that question an interrogative question, or was that a question to determine what type of situation you were encountering when you arrived at that location?
To determine what type of situation I was encountering.
And when you actually observed the defendant's vehicle, did you observe any physical evidence in that vehicle?
Yes,
With the defendant having been drinking?
yes.
What did you observe?
There was an open vodka bottle in the rear passenger seat of that vehicle.
Was that open vodka bottle within arm's reach of the driver's seat?
Yes,
Did you ever question the defendant, John McGee, to solicit any incriminating information from him?
no,
Did you ask him the standard identifying questions such as your name, your address,
yes,
your driver's license?
yes,
And was the defendant able to provide those bits of information to you?
yes.
Can you describe for the court what was the defendant's speech?
A slight slur.
You testified the odor of alcohol and the glassy eyes. Anything else about his appearance that made you suspect he might be under the influence of alcohol?
No.
Did you ask the defendant to submit to field sobriety test?
Yes,
Did you ask the defendant to submit to an HGN?
no,
And why is that?
because I am not a DUI officer.
Did you ask the defendant to submit to the walk and turn?
Yes,
And have you administered the walk and turn to other persons during the course of your employment with the Atlanta Police Department?
I'm sorry.
Had you administered the walk and turn to other suspected persons under the influence of
Yes,
alcohol prior to this incident?
yes.
I'm sorry, is someone's phone on? Okay, sorry about that.
Always.
Okay.
And Officer Ho, did the defendant agree to participate in the walk and turn?
Yes,
And was the defendant able to complete the walk and turn?
no,
And what did you observe regarding the defendant's ability to perform the walk and turn and to follow your instructions?
I observed that he was not able to follow directions. He started the test a little bit too early, as well as taking 2 to 3 steps on the walk and turn, and then basically stumbled and almost fell to the ground. At that point, he could not further go on with the walk and turn test. That's when I placed him in handcuffs and told him that he was under arrest for DUI.
And what made you determine that the defendant was unable to proceed with completing the walk and turn or any other evaluated field sobriety test at that time?
This staggered walk.
And did you form an opinion as to whether or not this defendant was under the influence of alcohol?
Yes.
And what was that opinion?
That he had a little bit too much to be drinking that day, and that all the stuff that I've seen, the smell, the everything on the eyes, and not being able to maintain his balance.
And did you form an opinion as to whether or not the defendant was safe to operate a motor vehicle?
No.
Did you form an opinion about whether or not he was able to operate a motor vehicle?
Yes.
And what was that opinion?
That he cannot drive.
And did you form an opinion that he was less safe to drive a vehicle?
Yes.
And after the defendant was placed into custody and taken to the Grady Detention Center, did you have any other encounters with this defendant?
No.
I asked you whether or not you had ever interrogated this defendant. I believe your testimony was that you had not questioned him to solicit any information from him. Was that your testimony, Officer Hill?
Yes, that's correct.
Other than the dexterity exercise of the walk and turn, did you ever ask the defendant to submit to any other or compel him to submit to any other acts?
No. So I did ask him.
Let's not.
Okay.
We're not going to.
Okay.
Other than field sobriety test.
Okay.
Stop. And Judge, that was in conformity with the court's rule. And I believe that that is all of the, those are all of the questions that I have for you, Officer Ho. Thank you, sir.
All right, Mr. Sullivan, your witness for cross.
Thank you, Judge.
I'm sorry, Officer Ho, we do have a court reporter on Zoom, so that's why I'm going to keep asking you to speak up.
Okay.
And I know the microphone is, you're much taller than the average person, so I'm sorry, the microphone is a little lower.
Yes, ma'am.
All right, please continue.
Thank you. And Officer Hill, I have bad hearing. So I appreciate you speak up for me as well. So you responded to the scene and Mr. McGee, he was already in the ambulance, correct?
Right.
Okay. And you said there was other witnesses on scene as well?
Yes.
Okay. And those other witnesses, did you speak to those other witnesses or did somebody else speak to those other witnesses?
Someone else did.
Okay. And do you know whether you did not personally speak to the mother whose vehicle was allegedly struck?
No.
Okay. Are you sure that you saw her on scene or are you just speculating that she was there?
I believe I saw her there. Yes.
Now, you indicated that Mr. McGee struck a mailbox.
Yes.
Okay. Is that mailbox part of the property that he and his family owns?
I did not know that.
Okay. Now, the damage you saw on the pickup truck is consistent, the 12 to 2 o'clock position of striking a mailbox, correct?
Correct.
Was there any other damage along the other side, the rest of the vehicle at all, or just the front 12 to 2 o'clock position?
There was 12 o'clock, 2 o'clock, and 3 o'clock.
3 o'clock, so around the same area.
Right. Yeah.
Consistent with striking a mailbox.
Yes, sir.
Okay. One moment, Judge.
Mhm.
Now, you placed Mr. McGee, you had an opportunity to watch your video before this hearing today, correct?
A little bit of it, yes.
Okay. You at some point when he exited the ambulance, you placed him into your patrol vehicle, correct?
Yes.
Okay. At some point, and he was in the back of the patrol vehicle, is that correct?
Yes.
Okay. And if your vehicle is like any other patrol vehicle, once a person is secured into the vehicle, they cannot get out unless you operate the handle to let them out, correct?
Yes.
They can't get on their own.
Yes, they can.
I'm sorry, they can't.
Yes, they can.
Okay. And so you approached your patrol vehicle after talking to Officer Smither at the time, now Sergeant Smither, about possibly doing field sobriety with Mr. McGee.
Yes,
Okay. And then, so you went to the patrol vehicle that Mr. McGehee, you placed Mr. McGehee in, correct?
yes.
Okay. Do you recall how long he was in the patrol vehicle before you got to it?
I would say about approximately 10 minutes.
Okay. You're also, you're also familiar with talking to Mr. McGehee that he was recently released from the hospital from cancer treatment. Is that correct?
Yes, I believe so.
Now, when you got him out of the vehicle, you wanted him to do field sobriety evaluations, correct?
Yes,
As a matter of fact, you told him that he had to do field sobriety evaluations. Is that correct?
yes,
Okay. And he told you several times, I can't do it. Is that correct?
yes,
Yet you still persisted on having him perform field sobriety. Is that correct?
yes,
Okay. And at some point, you just terminated the field sobriety evaluations, correct?
yes.
One moment, Judge. That's all.
Thank you. Any, all right.
Officer, Ho, your testimony on cross-examination was that you told the defendant, did you tell him or did you ask him if he would submit to field sobriety test?
I believe I told him.
And when you told him, which test did you tell him? Did you tell him that he needed or that he had to submit to these tests? Or that they were voluntary?
Honestly, I can't recall if I asked him for the field sobriety or if I told him.
But you don't recall.
I don't recall.
Was your determination that that the defendant was under the influence of alcohol based solely on what you observed when he attempted to complete the walk and turn?
Yes.
Was it based solely on that? No other evidence?
No, there was other evidence.
And so was the other evidence what you testified to previously regarding the odor of alcohol, the glassy eye, the inability to keep his balance?
Yes.
And let me ask you this. Do you see the defendant here in the courtroom today that's been identified as John McGee at the scene on August the 3rd of 2018?
Yes.
And if you would point to him and identify an item of clothing that he is wearing.
He's wearing a gray button-up shirt.
Let the record reflect that the witness has identified the defendant, John McGee.
So noted.
The why did you place the defendant in the patrol vehicle?
Honestly, when he walked down the ambulance, right,
I didn't understand. He walked out of the ambulance?
yes, after he refused the services with the EMS, he walked down the ambulance and he appeared to be intoxicated. He was swaying back and forth, and I did not want him to be injured, so I put him briefly in the back of my patrol vehicle.
And when you put the defendant in the back of your patrol vehicle, was he in custody or under arrest?
No.
Was that for his safety?
Yes.
And I believe, last question. The damage that you testified to that you observed at the 12 o'clock, 2 o'clock, and 3 o'clock position on the defendant's pickup truck, was that consistent with the information you received about the mother's vehicle and the mailbox having been struck and the vehicle that you observed stuck in the driveway?
Yes.
I have nothing further. Thank you.
Thank you. All right, does the state have, Officer Hall, thank you very much. You may have a seat, sir. Thank you. Does the state have any other witnesses?
No other witnesses.
All right, Mr. Sullivan, any witnesses or argument?
No witnesses, Judge, just brief argument.
All right, we may proceed, Mr. Sullivan.
Judge, I have to concede that there's probably sufficient probable cause for the arrest. As far as the field sobriety, it does appear that Officer Ho, after pulling Mr. McGehee out of a locked patrol car, and there's no evidence that he advised him that he's just there for brief detention, that a reasonable person would believe they're in custody at that point. There is conflicting testimony from Officer Ho as to whether he told or asked Mr. McGehee to do field sobriety. But what Mr. Ho does remember, Officer Ho does remember, is Mr. McGehee saying, I can't do it. And then Officer Ho persisting that he do it. Well, at that point, it's no longer voluntary. So we're asking that the court suppress any evidence of the walk and turn evaluation as well as any evidence of the refusal.
And any other
Any other evidence of the refusal, Judge?
evidence of refusal? Thank you. Ms. McCutcheon,
Judge, I would ask the court, can you hear me from here?
you can go to the podium. I'm so sorry, but that's just the
Thank
way
you,
the
Judge, yes.
space is wired.
Yes, Judge, yes, Officer Ho did indicate that he could not recall whether he asked or whether he told the defendant to submit to the walk and turn. He said that he did not recall, but there's no evidence that the defendant felt that he was compelled to perform that. Officer Ho did testify that the defendant admittedly stated to him that he could not perform the one leg stand. He did not ask him to do that. He did not ask him to perform the HDN because he testified he's not a certified DUI investigator certified in the conducting the HDN. I'd ask the court to find that there is no evidence that the defendant was compelled to complete the walk and turn. So I'd ask the court to allow that in at the trial of this case. I'd also ask the court to deny the defense motion to suppress any compelled acts. The only act that I could imagine the defendant would be alluding to as being compelled would be the walk and turn, since there's no evidence that this defendant was ever asked to or compelled to do anything else. Regarding defendant's motion to suppress any statements, there's no evidence that this defendant was ever questioned, interrogated, or that there was ever any attempt to solicit information from him without him having been properly Mirandized and advised of his constitutional rights. I'd ask the court to deny the defense motion to suppress compelled acts as violative of the Georgia Constitution, as well as I'd ask the court to deny the defendant's motion to suppress statements since there's been no evidence of any statements. The officer did testify the defendant admitted that he had consumed a pint of alcohol, but that was in response to his typical investigatory questions when he arrives at a scene. What is your name? Where do you live? Where are you going? What have you been doing? Do you have a driver's license? Is this your vehicle? That was not an interrogation by asking the defendant when you arrive at a scene where there's a suspicion of a DUI driver as to whether or not that driver had had anything to drink. And Officer Ho testified that he responded to a suspected impaired driver when he arrived at that residential location. Based on the evidence that has been presented today, Judge, I would ask the court to deny all of those defense motions that are appropriate and those that we addressed in this motion today. Thank you.
At the beginning of the hearing, we had gone over with defense counsel as to what are the remaining issues to be challenged in this particular motion, in limine and motion to suppress. And based on the information that has been elicited, the evidence that's been elicited today, the court finds that there is sufficient probable cause. As Mr. Sullivan also indicated that the court would be inclined to find that sufficient probable cause for the DUI that's safe, in addition to the other charges of reckless driving, hit and run, failure to maintain lane or improper lane change with respect to Mr. John S. McGee. With a few notes on the alleged improper detention in the police car. Based on the totality of the circumstances, the observations by Officer Ho and based on his training experience, the court finds that the placement of Mr. McGee in the police car for the duration that he was in the car was not illegal. That was part of the officer's investigatory process. There is sufficient case law that has indicated what would be considered an improper length of time. And the evidence that's been shown so far has not indicated that it was an improper length of time. So the court does not find that this was an illegal detention, and any statements elicited during the course of that portion of the investigation shall not be suppressed. The walk and turn, now whether that was done under compulsion, under duress, whether the officer was forcing Mr. McGee, Officer Ho testified that he told Mr. McGee to do the test. I don't have sufficient information that Mr. McGee indicated that he refused, that he couldn't do the test, or that he was physically incapable of doing the test. I don't have sufficient information with regards to finding it that it was done under duress. Now, I also don't have sufficient information to indicate that Officer Ho was forcing Mr. McGee to do the test. So the request to suppress the walk-in turn test is denied. This case will be further noticed for trial. Mr. Sullivan, I'll be glad to schedule this for a jury trial on our Orca calendars. The jury trials for the Orca calendars will be held on Thursdays. And those are jury trials, as well as if you request a bench trial, we schedule them on Fridays. So I'm going to let you and your client confer, and whether you and Ms. McCutcheon would like to have a discussion further down the road. That is something y'all can consider as well.
Thank you, Judge.
All right, that concludes this case. Thank you. And Ms. McCutcheon, you can submit a proposed order. Ms. Marshall Story, you can submit a proposed order with regards to case we had involving Mr. Taylor on this story. Okay. All right, Mr. Sullivan, any questions?
No, Judge.
All right, thank you, folks. I'm just going to go over my all right, folks, our litigation manager's announcement on which case? Yes. Yeah. Okay, with Miss Barty. Oh, 4, excuse me. I thought I heard 1. All right. So Matthew Littlefield? Yeah. Okay, so that case is reset to December 16th at 11:30 a.m. Okay, thank you. Thank you. All right. Do you need me to go over the calendars again? We good? Miss Marshall Story, Miss McCutcheon?
I believe the fine judge.
All right, I don't have any. Miss Helen, we good? She's here, she's not here? Okay. All right, Miss Greenhouse, thank you. Very shortly, we're going to start with our bench call calendar. It is 1:34. Who's our litigation manager for the bench calls? All right, lucky you. We'll take a 10-minute recess. How's that? Okay. Folks, we're in a 10-minute recess. Thank you. resume with our bench trial calendar. If I can get the video started. All right. Good afternoon, ladies and gentlemen. My name is Judge Lal, and we are going to begin with our bench trial calendars under the Orca program for today, October 28th, 2022 at 1:30 p.m. We have two separate bench trial calendars, and I'm going to ascertain the status of these cases. Let's begin with our Orca E bench trial calendar. I have 3 cases scheduled on the calendar, and I'll expect at least one ASG to let me know what's the status of how they're going to move forward with these cases. The first one, we're going to address position number 3, Jennifer Rochelle Wilkie, 20 CR 0044119Y. During the recess, the state has announced its intent to null cross the charge of battery domestic violence. Defense counsel was informed of the state's intent and has been released. So position 3 is now been closed out by null cross. Position 2, I have Talicia Powell. Ms. Powell, if you'd like to stand up and come forward to the table right in front over here. Yeah. Ms. Powell, you have a right to remain silent. Anything you say about the facts of your case, statements can and will be used against you. You have a right to an attorney. If you couldn't afford one, one could have been appointed to represent you anytime since the initiation of your case. I'm not certain why you have not sought out public defense attorney, and I'm not certain why you've not hired a private attorney. But if you choose to represent yourself, you are responsible for how the law applies to the specific facts of the case. You're responsible for all legal decisions that you make and how that may impact with regards to the admissibility of evidence that's brought against you, with regards to the evidence that is brought by the state against you in order to carry its burden of proof of proving the charge against you beyond a reasonable doubt. Keep in mind, the prosecution has the entire burden to prove the charge against you beyond a reasonable doubt. Your legal understanding of that phrase, beyond a reasonable doubt, is your responsibility. Do you understand?
Somewhat, Your Honor.
All right. So at this juncture, this case is scheduled for a bench trial. That means the judge will determine what are the facts, what the credibility of the witnesses, and ascertain the weight of the evidence before the court decides whether the state has carried its burden of proof or beyond a reasonable doubt. And then after that, it will be you as the defendant to decide how you would like to proceed. Keeping in mind that you have a right against self-incrimination and a right to remain silent, and that cannot be held against you. So if you choose not to testify, if you choose not to say anything on your behalf, that's entirely your right, and that cannot be held against you. You understand? But you do have a right to subpoena witnesses, which you should have done. You do have a right to cross-examine any witnesses that the state will present. And you, so those are your rights. And if you choose to rely on those procedures in order to challenge the state's evidence, that would be your right as well. You both have a right to make an opening statement. You both have a right to make a closing statement. At the conclusion of the trial, I will then render a decision. If I find that the state has carried its burden of proof, of proving the charge of destroying, removing, concealing, encumbering, transferring, dealing with property subject to a security interest, if the court finds that the state approves that charge beyond a reasonable doubt, then you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Do you have any questions at this juncture?
I have a question. I was under the impression this was to set the date for the trial. Is this indeed the actual trial?
Before I answer the question, can you tell me why you believe this was a scheduling calendar?
Because that's what I heard when I did the Zoom call, that I had to go in person to schedule the bench trial.
Did you respond to the calendar today pursuant to a written notice?
I did.
And did the written notice say this was a scheduling calendar or a bench trial?
I'm not certain. I don't have it in front of me right now. So I didn't know, I thought this was to set the date to get information and things like that. I didn't know this was the actual day.
Okay, what's your next question?
I did, because I thought that it was scheduled, I did bring proof because I was told that I could not get representation of a public defender over the Zoom calls, but they didn't ask for proof of income or things like that. So I brought those things showing that I do qualify for it, even though I was denied it without getting any or being asked to prove if I was or wasn't. So I wanted, like I said, I thought I would be able to bring that, showing that I, qualify for a public defender.
Okay.
Since without being able to provide that information over the phone, I thought I would be able to do it in person.
And what led you to that impression?
Because I thought this was to set the date for the trial.
Do you have any other questions?
Not at the time.
If I have a reasonable basis that you believe this to be a scheduling calendar as opposed to the calendar in which we're having a trial, I would certainly entertain your question, but I have no indication on the notices, on the information that was provided in Zoom and so forth, that this would have been a scheduling. So you should have been prepared for trial today. You were informed on the Zoom calendar, as you just indicated, that you did not qualify for the services of the Public Defender's Office. If you wanted the Public Defender's Office to revisit that issue, you should have made an appointment with the Public Defender's Office before today's date to establish whether you qualify for the services of the Public Defender's Office. And so you chose to fail, and you failed to do so. So we are moving forward. All right. I have one question. Does the state have any offers with regards to this particular charge?
Your Honor, the offer is either to pay the restitution of $3,074.03.
Excuse me, Judge Law, I apologize.
No, got it.
I'm not seeing people. Some of the boxes fell off for some reason. I was able to hear Ms. Powell speak, but not see her. And just wondering if.
The Zoom has concluded on this end of the screen. So Mr. Jordan is going. Mr. Jordan, are you going to reboot this?
I will. It was set for the SCA calendar, so I'll cancel that one so she can log it back.
Okay. Yes. All right. I'm sorry. Go ahead, Ms. Githia.
Yes, the offer is to either pay the restitution of $3,074.03 or to turn in the 2010 Nissan Sentra.
Okay. Pay or surrender the 2010 Nissan Sentra, and to whom would it be surrendered?
American Title Loan.
All right, Miss Powell, you're going to have a seat now, and you will make a decision as to whether you're ready to move forward with the trial or whether you would like to consider this plea offer.
Thank you, Your Honor.
All right, and do you understand the option?
I do.
All right, and you understand that you're not to leave this courtroom?
Yes, Your Honor.
And unless you want to use the facilities, okay? And I need a decision when I call your case for trial.
Thank you, Your Honor.
All right, thank you.
Ms. Powell, Ms. Powell.
Oh, yeah.
You need to put a big sign on that door. Okay, Ms. Greenhouse, I'm just trying to get a status of the cases right now, so.
Everybody else come in.
Thank you.
Keep the outer ones, because this makes a lot of noise going in. Just walk. Yeah, just walk around. Okay, thank you, sorry.
Thank you, sir, thank you. All right. Mr. Ross Dixon, represented by Brandon Dixon. Mr. Dixon, this is case 20 CR 002247Y. Anyone present for that case?
Yes, Judge.
All right, thank you. And Attorney Dixon, your client is ready to move forward with the bench trial.
Yes, Judge.
All right. What about the state?
Yeah, the state is prepared to move forward.
All right. And how many witnesses does state have?
There are 3 witnesses, Your Honor, and all 3 are seated in the courtroom.
Okay. All right. Logistically, as we're going to be doing it in such a way that the witness is actually going to testify on this podium, and the attorneys will position themselves in the courtroom so that they can observe the witness, they can listen to the witness, and so forth. All right. We do have some logistical challenges in this courtroom. So as soon as that Zoom is up and going, we can begin with the first bench trial. Okay. And Mr. Attorney Dixon, do you have any witnesses or any evidence that you all plan to present?
No, Judge.
Oh, thank you. All right, now we can begin with the Dixon trial as soon as we get the Zoom up. Orca B bench trial calendar. Miss Marshall Story or Miss McCutcheon? State versus Charlie Limpty Eddie, 20 CR 003435.
That out of respect for your Honor, the state was not aware of this, I'm looking at the term. Not myself, my colleagues were aware of the respect for your Honor, this work has been filed. One of the cases was reset, so why I'm looking at the case, your Honor, that's called the Limpty case. On July 29th, bench trial calendar, and it was reset to the day that.
Yeah, it was on July 29, 2022. And that was
Chief Judge, other than he's not aware of this calendar, neither myself and my colleague recall receiving the email of the calendar. I'm not saying that the state has it, email, I'm certain that they did, but for whatever reason, we were not aware. Either with that looked at or whatever the reason. But directly, Judge, I would ask that we continue, but alternatively, the things that they either both neither of the defendants are represented by counsel. The Maurice Robertson case, Judge, is the public safety case. The Charlie Eddie case is the family violence case. The state has no excuse to the very serious cases, especially the fact that the Maurice Robertson case and the prior aggravated history. We'd ask the court respectfully to continue these cases to the next bench trial calendar. I will speak to the see if we can negotiate something. Judge, we're not here to go forward.
Charlie Eddie. All right, Mr. Eddie, would you like to come forward? The other way. Don't use those double doors. All right, Mr. Eddie, you have a right to remain silent. Anything you say about the facts of the case, your statements can and will be used against you. You have a right to an attorney. I guess you do not qualify for the services of the public defender's office. So you have the right to retain your own counsel or represent yourself. If you choose to represent yourself, you're responsible for understanding how the law affects your facts of your case and also any legal decisions that you may make. The state is arguing that they do not get notice of this trial calendar. Do you want a continuance? Do you have a response?
I do, as well as the
Go ahead.
defendant, Ms. Brown didn't receive notice as well. And that's to my understanding that the case could or would be dropped with her not pressing or pursuing charges, which she was not, which we were prepared on July the 29th to have the case and trial, which was reset to today. So that's two unknown, which we find out on the 29th in court, and it's happening again today. And I'm constantly just trying to resolve it. I didn't have representation because I was counting on her testimony of never pressing. I mean, she didn't file this charge in case to start with and doesn't pursue, which I have.
It's a criminal case. Why would the victim file a case?
Well,
I mean, I hear that argument all the time. The victim doesn't file the case. The prosecution files the case. That's why it's called State of Georgia versus.
maybe I'm totally misunderstanding from the very
The
beginning.
criminal case,
Mhm.
right? Okay, so is Miss Brown here today?
She wasn't because she didn't receive notice of the case. I reached out to her. I actually thought it was a Zoom and realized at the last minute there was no Zoom option. So I rushed down here today to be in person. She would only be available by phone or something, but no, she's not here present.
And did you receive notice of this hearing?
I did at the very last moment.
Hmm?
I did at the very last moment.
When?
I received notice here within a week.
Okay.
Yeah.
Yeah, I need to know when the clerk's office has sent out notices on these two cases.
So according to the notice hearing, obviously, it was 10/6. So.
And if I respect, I might ask, can you show the date that the calendar was emailed to the state? Because we received the Orca bench trial, but we were not aware of this. If you can tell us the date.
Ms. McCutcheon,
Yeah.
I'm checking the emails now. Both of the litigation managers who are handling this are on medical leave, so I'm going in and trying to check emails now.
All right, thank you, Ms. Jane.
Okay. All right, and it's going to be the same situation with Mr. Robertson's case. Mr. Robertson, when did you receive notice of this trial? Date?
My initial on jury trial. And I talked to my attorney, Raymond H. Stein. He told me to come in and ask for the case to be dismissed. This has went through 5 different judges. And
Stand up, sir. And my only question to you was, did you receive notice of this bench trial calendar?
my bench trial, no jury trial, I have a copy of it on my phone.
All right, and what does that notice say?
Sent, October, this is October 6th. At 1:30, 10:28, non-jury trial project. Orca project non-jury trial.
Non-jury trial. Okay, so you did receive notice. And what was the date of that email?
I never got an email. I got the actual letter in the mail.
You got the actual letter in the mail?
Printed it, I took a photo.
Okay, what's the date on that letter?
October 6th.
Okay. Thank you, sir. That's all I need to know. So I'm still confused why the state did not get notice. Who was the litigation manager for Orca B bench trial calendar?
She mailed out those notices on 10/6 for the Orca. Notices were mailed out.
No, we don't have a problem with Orca E. We have a problem with Orca B.
Your Honor, if I may.
Yes, Ms. Riley.
Good afternoon. So I see that there are emails for Orca bench trials on Wednesday, October 26th that we received for Orca B. We have not received any emails with any calendars for bench trials today, Friday, October the 28th.
Okay, okay, so in that regard, the alleged victim and the officers for these cases have not been subpoenaed?
That is correct.
All right.
As we did not have notice. Thank you.
All right. Mr. Robertson and Mr. Eddy, it looks like this was a big hiccup from the clerk's court that we did send the notices out, but the notices for this calendar was sent out for October 26th instead of 28th. And I'm not going to exclude the state's right to pursue these cases. So I'm going to reset these cases for a bench trial calendar. And in a bench trial calendar, the alleged victim has a right to be notified that this case is going to pursue, is going to move forward on a trial basis. Do you understand, sir?
I believe I
Yeah.
do.
As you just told me, Miss Brown did not get notice of this trial until last minute, yesterday. She should have gotten timely notice. And the Victim's Bill of Rights does entitle the victim to appear in court when a trial is proceeding. Now, whether the victim decides to testify for the state and against you, that's entirely up to the victim. All right? Do you understand?
I do, or, I mean, are we able to call or contact, because I'm like, this is my 5th attempt, you know, and it's almost like the same results with no
I
resolution.
agree, sir. I agree, but we've been going through a lot of calendaring difficulties, and believe me, these are the least of them. So I'm going to reset this case for the next bench trial calendar. Do you have a new email and a new address by any chance?
No, ma'am.
Okay, notice will be sent to you. Thank you for being here.
Thank you.
Mr. Robertson, I have the same notice for you. I'm going to reset this case because the state did not get adequate notice of this bench trial calendar. New notice will be sent to you. Is there any difference in your mailing address and your email? And now I have another question. You mentioned an attorney. Who's your attorney?
Brandon H. Stein.
Who?
Brandon H. Stein.
And why is he not here?
He told me it was a non-jury trial, and he himself, this case is went through 5 different judges.
That doesn't matter. They can go through 10 different judges.
He was saying it should be dismissed.
Okay.
Because he was on the scene with you in the car that night. He's one of the police officers. He told me, y'all can call him, get to the car, because the police who actually arrested him was fired.
Give me a legal reason why the case should be dismissed. 5 different judges is not.
This is one of the officers who was actually there. This.
Is that officer, did you subpoena that officer today?
Yes, Sergeant L. Carter with South Fulton. He was actually one of the.
Listen to my question. Did you subpoena that officer to show up today?
Carter?
I don't know. I can't read that far.
He just told me, yes, bring the car and y'all call him.
Okay,
So in a sense, I did subpoena him to come, but
you did? When?
I've been, every time this case, this is floating around 3 years. So every time it comes.
Listen very carefully. This is the last time I'm going to ask
Oh,
this.
yes, I did, yes.
Did you subpoena that officer on the card that you're holding for the trial date today? You did. And I see a copy of your subpoena.
Well, I don't know. This is, how can I subpoena a cop from?
When you go to the clerk's office and you request a subpoena for a witness to appear.
Okay. He just gave me the card.
Right. So you're going to talk to your attorney. And if you still choose to represent yourself, ask your attorney, how do you subpoena a witness to appear and support your statements?
Okay.
All right. Your case is going to be reset, and make sure you're prepared next time, or better yet, bring your attorney.
Yeah, I will.
Thank you. Free to go. All right, we are going to proceed with 20 CR 002247Y. Mr. Attorney Dixon, do you want me to sequester the witnesses
Yes, Judge.
at this juncture?
Yes, Judge.
All right. We're going to have which witness is going to be testifying first?
Your Honor, the first witnesses is Deborah Jones.
Okay.
The other 2 witnesses are police officer witnesses. And
Okay.
they're sitting here, so-
All right. Would the officers please step outside and go to the, as soon as you step out, you'll be moving to your extreme left hand of the hallway. All right. I'm sorry. I'm just going to have you exercise the honor code, not to listen to this trial. All right. We're going to begin with the opening statements.
Judge, but before the court begins, I would like the court to know that the state has consented to my motion in limine. So
Okay, news to me. What is the consent?
that there
You
was.
stand up and address the court, sir.
Yes, Judge, that there was a there's a refusal in this case. And the refusal is being restricted from evidence because the officer didn't follow proper protocol as it relates to administering the test, Judge.
All right. I'm not certain how that applies right now, but Mr. McCutcheon?
Your Honor, I've not spoken to counsel, but I will respond. On behalf of the state, ASG Marshall Story did consent because this is pre-Elliott, Your Honor, this is the 2018 case. So based on the appellate court's ruling, the implied consent for refusal would not be admissible at trial.
Okay.
So that is why we conceded to that motion in limine.
All right.
They will not solicit any evidence from the officer regarding the refusal.
And also, Judge, if the state is going to, I guess, be showing the video should be earmarked where, before that point in the arrest comes to the court's attention.
Understood. And also as the trial fact, the court can disregard if that portion of the evidence is in because of this ruling on the motion in limine that any evidence of any evidence of an alleged refusal shall not be admissible.
Thank you, Judge.
And Judge, I was just going to ask if the court, I know the court will disregard because the court has to hear the motion regarding the inadmissibility of the refusal. So the court is aware of that anyway. So just have to be able to play it in its entirety.
Understood. Thank you. All right. Any other motions to address any other preliminary matters? No? Okay. Mr. Dixon has, I've already advised him of his right to remain silent. Anything he says during the course of his trial, his statements can and will be used against him. He does have a right to remain silent. And if he chooses to exercise his right to remain silent, that will not be held against him. Okay. Opening statements. And we can take that from the podium because the audio is just so much better.
Yes, sure. Good afternoon, Your Honor. Erica Marshall Story. It's really loud. Erica Marshall Story for the Fulton County Solicitor's Office, State of Georgia. Your Honor, I will be brief in the opening. The evidence will show that on December 9th, 2018, at approximately 2:15 a.m. in Fulton County, in the area of I-75 and 85, the southbound lane, by the Fulton Street Bridge, Your Honor. The defendant, Ross Dixon, was driving a black pickup truck. That pickup truck, the evidence will show, went from the far left lane to the far right lane, striking another vehicle, then bounced off of that vehicle and went back and hit the median, causing the truck to then flip over several times. Your Honor, the evidence will show that the defendant was driving the vehicle under the influence of alcohol. The evidence will also show that the defendant was driving the vehicle in a reckless manner, failing to maintain lane, and that finally was moving too fast for road conditions. Pursuant to that information, Your Honor, the officer will also be able to testify that the defendant was driving the vehicle with an expired license. I'm sorry, an expired tag, Your Honor.
Okay.
Your Honor, we would ask most respectfully that the court take note of the officer's testimony regarding the testing that was done, the observations that were done, and the witness's testimony that you will hear from very shortly. Your Honor, we would ask most respectfully that you find the defendant guilty on all of the charges, and the state will close with that. Thank you.
Thank you. Thank you. Attorney Dixon, do you have an opening to make?
Just very brief, Judge.
Yes, sir. And I do apologize for addressing you as Attorney Dixon just because coincidentally both of you have the same last name. So
No problem, Judge. Judge, it's our position that the evidence is going to show that Mr. Ross simply got into an accident and that he did admit to consuming some alcohol prior to that accident. The officer's investigation, however, was not in accordance with NHTSA standards, and the officer failed to follow proper procedure as it relates to administering field sobriety tests. And because of that, Judge, it's our position that there is no evidence to support that Mr. Dixon was driving under the influence to the extent that he was a less safe driver. Judge, as you know, it is not illegal to drink and drive in Georgia. It is illegal to drink and drive when your alcohol blood content is above 0.08. In this particular case, Judge, it was, as the evidence will show, a pretty severe accident. The video will show that Mr. Ross was disoriented due to having sustained what appears to be some type of head trauma in the accident. And without the officer following proper NHTSA protocol, he began to administer field sobriety tests without assessing whether my client was medically impaired versus impaired due to the influence of alcohol. So because of that, Judge, we believe that there's no sufficient evidence to support any of the charges because my client simply was driving his vehicle, hydroplaned, and got into an accident. And I don't think anything in the evidence that the state will produce today will support any of those charges against Mr. Dixon. And because of that, Judge, we would ask that he be found not guilty on all charges.
Thank you. State may call its first witness.
Your Honor, the next call is Ms. Deborah Jones.
Do we have a chair for Ms. Jones? It looks like there's one over here. Ms. Jones, we're gonna get a chair right there. I'm sorry, and we're just gonna lower the microphone. Okay, Jesse? Okay. Thank you so much. Okay.
Thank you.
Ms. Jones, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes,
Would you please state your full name?
Deborah Renee Jones.
All right, thank you. Ms. Master Stewart?
Good afternoon, Ms. Jones. I'd like to start, and we are in front of the judge, so please feel comfortable, be comfortable. But please, obviously respect that this is still a bench trial, but you don't have to be quite as formal as you normally would expect.
Okay.
So, all right, thank you so much for coming in, Ms. Jones. Can you tell us what your occupation is?
I'm retired right now. I used to work for the state of Georgia Department of Motor Vehicle.
Okay, and I'd like to direct your attention to December 9th, 2018 at 2:15 in the morning at I-75 and 85, the southbound lanes by the Fulton Street Bridge. Now, Ms. Jones, I know you recall that date and time, but let me ask you, do you recall that date and time?
Yeah, the day before my birthday,
Okay, and when was your birthday?
December 10th.
December 10th. Okay. Can you please tell the judge what occurred at that date, time, and location that you recall?
I had just dropped off one of my friends. Well, on the weekends, we get together and we go to Birmingham to play bingo.
And you can, talk.
Okay, and so I had just dropped off Miss June, which lived off of Boulevard. And me and Miss Maddie Ruth was coming back because I was taking Miss Maddie home, which she lived off of Cleveland Avenue. So we were coming 75 South. And we were coming around that Grady curve. And right now I still feel Grady curve from that night. But we were coming around Grady curve. And as we were coming, me and Miss Maddie were talking. Then all of a sudden, boom! His truck came directly into my van. And I'm trying to hold my van So me and Miss Maddie don't go into the concrete wall because I'm like, Lord, I can't die. Tomorrow's my birthday. So when I kept control and I was looking, I could see his truck. His truck was flipping, flipping, flipping. And I'm like, Lord, I hope whoever's in there didn't get killed. I said, because we almost died tonight. And I got on the phone, I called 911.
Okay, I'm gonna pause right now. Next question, please.
Yes, let's explain this a little bit further. Ms. Jones, what lane were you driving in?
I was in the far right lane.
All right. And what vehicle were you driving?
I was driving a 15 passenger, 3500 Chevrolet Express.
And how many passengers were inside of that vehicle through that van?
It was just two then, me and Miss Maddie.
And where's Miss Maddie?
Miss Maddie has passed away. She died of COVID.
Now, what seat you were the driver, is that correct?
Yes,
And what seat was Miss Maddie?
she was in the passenger seat.
Okay. Now, please explain to the judge, the lighting conditions. Were you able to see clearly?
Yes,
Okay. And do you recall what the weather was like that day?
the only thing I can really remember is when I got hit. And I'm like, I don't believe this.
Did you see the defendant's vehicle coming toward you?
From the side, when it was like, I didn't really see it until he got there. And when he hit me right in the driver door. Right in the driver door. And I went this way trying to keep control of my van, and his truck was going backwards.
Okay. Now, did you obviously eventually came to a stop? Is that correct?
Yes.
And tell the court what happened after that, or what you call it.
I was talking to someone on 911, and like, I've been hit, but they thought I was talking about being shot. And I was like, no, I'm in my vehicle, I've been hit. And it was almost like, when I stopped it, it was almost like pinned to the wall, because Maddie was on the passenger side, but we couldn't open the door. And then on my side was KB when he hit. But
Were you able to exit the vehicle?
no, the police officer wouldn't let us get up, so I'd have to crawl over Miss Maddie and then try to go through the window or whatever. We were just pinned to the wall, and my vehicle was crushed in so that door wouldn't open. It was just.
Did an ambulance come up to the scene?
Yes.
And did you have any?
At the time, no, because I was just shook up. Miss Maddie, she was shook up too. And I just wanted to go home because the next day was my birthday. It was my birthday, so I just wanted to make sure that I got home.
And eventually you did.
Yes.
Take them home. And how were you able to get?
Well, after I did get Miss Maddie home, and I was getting ready to go home, then the van didn't drive anymore. It just stopped pulling. I guess the transmission had lost all the fluid or whatever. And I called AAA. And this was like after 2:00 in the morning. I called AAA. And AAA didn't get to me till 8:30 that morning.
So you were on the scene until 8:30 that morning as a result of this accident?
When I dropped Miss Maddie home, yes. I just couldn't go home because the van wouldn't move. And then they totaled it out.
All right, and did there come a time when you learned who the defendant was?
I never knew who he was, only heard his name.
And what name did you hear?
They said Mr. Dixon.
Did you ever actually see?
Yeah, I never met him, don't know him.
Yes, did you ever see? Excuse me, Judge Law?
Yes, Ms. Greenhouse?
I'm sorry to interrupt. I'm just having a little trouble hearing the solicitor.
All right. Ms.
Thank
Marshall,
you.
sorry, you would have to speak up. Sorry.
Would you like me to repeat something, Ms. Greenhouse?
Thank you. I think I've got it, but just if you could go a little bit louder going forward.
Yes.
Thank you.
I will do that. All right, Ms. Jones, is there anything else that you recall from this incident?
No, that was it. I mean, it was just a terrible night, that's all. One that I really don't even want to remember. And when I come around Grady Curve, that's all I can remember. Every time I come around Grady Curve, you know, I'm looking to make sure nobody's coming.
And do you recall the weather at all that day?
No,
That evening?
no, I really don't.
Okay, do you recall having any difficulty driving your passenger van?
No, now I remember it was raining. It was raining because when the police officer, when she came to my van, it was really raining hard. And she was like, I don't want you to get out in the weather. You're not going to even try to get you out of the van. And she said, are you all right? I said, yes. Do you need to go to the hospital? I said, no. I said, I just want to get Miss Maddie home and I want to go home. But, excuse me, but they had 75 completely locked down. It was completely locked down. I mean, every lane was completely locked down.
And this was as a result
Of the accident. Mm-hmm.
Nothing further.
Right, thank you. Attorney Dixon, if you'd like to reposition yourself where Ms. Marshall's story was standing, we may proceed with cross-examination.
Yes, Judge.
Ms. Jones, this is Attorney Brandon Dixon, and he's going to ask you some questions about the testimony you just presented, okay?
Ms. Jones,
Hi.
I'm sorry that you had to experience that on the night of this incident. I'm just going to ask you a few questions about your experience. I'll be brief. Is it correct that your testimony is that you didn't see Mr. Dixon's vehicle prior to the impact?
No, I've never seen a vehicle.
Since you did not see Mr. Dixon's vehicle prior to the impact, you wouldn't have any idea how fast he was traveling, correct?
No, but the only thing I know, he came from the far left lane all the way to the right lane.
Also, since you didn't see his vehicle prior to impact, there's no way that you could determine if he was driving with a reckless disregard, correct?
Well, see, the way he hit me, he was reckless. He was reckless because when he hit me and his vehicle kept turning over and over and over. That was reckless.
So it's your testimony that just because he collided into you, that was a reckless act?
He wrecked into me.
You indicated that you had no injuries at the scene of the accident, is that correct?
No physical, nothing, no.
At any point that situation changed?
Yes, it did, because I did have to go to the doctor, whereas I was being treated already for some things. So it more or less impacted more of what I was going through.
And as a result, did you file any claims against his auto insurance?
Yes.
Objection, Your Honor.
What's the objection?
The objection is relevant, Your Honor. He's about to discuss something that has absolutely nothing to do with the four corners of this particular prosecution.
I'm not certain what he's about to discuss, but
Well, Judge, it goes to credibility. The witness says that she was not injured at the scene.
oh, so you're going to go further into her injuries then?
Yeah, well, she said that she wasn't injured at the scene of the accident, but then she subsequently filed a injury claim.
All right, good. And why do you believe that's relevant to the issue of the charges that have been brought today against Mr. Ross?
As it relates to whether we can, whether her testimony is credible, Judge, as it relates to the truth.
Okay, I'm going to sustain the objection.
No further questions, Judge.
All right. Any redirect? All right. Ms. Jones, thank you very much. We are not going to recall this witness, so I'm going to permit her to remain in the courtroom, or I'm going to release her. Is there any objection from either attorney?
Not from the state, Your Honor, it is completely up to the witness.
Not from the defense either, Judge.
Right. Ms. Jones, I'm so sorry, but I just want to let you know that you are free to stay and observe the rest of the trial. You're free to leave if you choose to do so. Thank you. Next witness, please, and the state's calling.
Your Honor, the state is calling Officer Sherrod Stansel of the Atlanta Police Department.
Miss,
To be outside.
yeah, Miss Giffey, if you could just pop your head out there and just call Officer Stansel, appreciate it.
Yes.
Careful, Mr. Dixon, I can hear you on the Mr. Dixon, I can hear you on the microphone.
I apologize, Judge.
No, you want to maintain that confidentiality, so.
Is there a way to disable the mic, Judge, when we speak? Just tap the button there.
If I hear you again, I'm gonna let you know, but
Can you hear me?
it's a very odd setup.
Can you hear me, Judge?
Yes, I can. Okay.
It was already on red.
He's got a hot mic in front of him, so I just want to make sure he realizes that. Officer, good afternoon. My name is Judge Lal, and you're going to be right in front of this mic. May I place you under oath, sir? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
All right. Now, we do have a chair back there if you're comfortable sitting there. Just need to bring the mic down so that we can hear you, and our court reporter is on Zoom, so it's very important that everyone speaks up, okay? Thank you. Could you please state your full name and your agency?
Sure, I'm Jamar Stansel, and I work for the City of Atlanta Police Department.
Ms. Marshall Story?
Thank you, Your Honor. Good afternoon, Officer Stansel. How are you?
I'm fine. How are you?
Just fine, thank you, sir. I am going to briefly ask you, well, not briefly, but ask you questions about an incident that occurred at 7585 in the southbound lane on December 9th, 2018. But first, can you begin by telling the court how long you've been employed with the Atlanta Police Department?
Approximately 7 years.
Okay, and where are you currently employed within the department?
I'm on the Apex unit, which is a violent crime apprehension unit. We serve search and arrest warrants, tactical operations, and deal with street level crime.
Okay, and about how many total years have you been in law enforcement?
8.5.
Okay, and where is that, someplace outside of Atlanta?
Yes, ma'am. I was a police officer in Illinois.
Okay, and what did you do there?
Basic 911 calls.
Okay, all right. Now, can you please tell the court what your duties and responsibilities were on December 9th, 2018?
At that point in time, I was assigned to Zone 3, specifically Beat 303. Zone 3 is the southwest portion of Atlanta. 303 consists of Mechanicsville neighborhood, parts of the Pittsburgh neighborhood, and on the highway, you have parts of I-20, and you have everything north in 7585 and south in 7585.
Okay, and so what were your responsibilities during that time period when you were with Zone 3?
You respond to 911 calls, and then if you have time, you can be proactive.
You can,
Be proactive.
okay, and what does that mean exactly?
Stop cars, traffic violations, things like that.
Okay, so general protection of the community.
Yes, ma'am.
Okay, all right. Now, I'd like to direct your attention to your training. Can you tell the court whether you are post certified?
I am.
Okay, and what exactly does that mean?
It means that in the state of Georgia, I am legally authorized to enforce the laws in the state of Georgia.
Okay, and do you have to complete certain certifications or training modules in order to stay post-certified?
Yes.
And tell the court a bit about that.
Every year you complete a use of force de-escalation, a firearms, and a cultural awareness.
Okay, and what specific training do you need or do you have to take to continue your employment?
It's just a yearly thing. It's, yeah, every year you do the same. Every year you have to take the same things in order to keep it posted up to date.
And have you passed all of those training modules?
Yes.
Okay. Now, I'd like to direct your attention in the area specifically of driving under the influence or detection of impaired drivers. Have you had any specific training in that area?
Yeah, so in 2015, I went through the State of Illinois Training Academy, Police Training Academy at SWIC, which is Southwestern Illinois College, and they have a police academy there. And during that, it was mandated in Illinois that you take a 24-hour NHTSA, which is the National Highway Traffic Safety Association, standardized sobriety class.
Okay. And what about in Atlanta? Have you had some additional training with detection of impaired drivers with the Atlanta Police Department?
The Atlanta Police Department does not require or does not administer additional tests for DUI.
Okay. Have you had any other tests or any other training outside of what is mandated by the Atlanta Department?
No. Besides the Illinois, no.
Now, have you had any training when it comes to DUI investigation?
In the state of Georgia? No.
And did there come a time when you were able to learn how to conduct those trainings and how to conduct DUI investigations?
Yes, I got all the training prior to coming to Georgia.
Okay. And so that training was accepted by your APD commanders that you received in Illinois?
Yes, it's a national certification.
Thank you. And approximately how many accident cases have you been involved in?
Oh, more than 50?
Okay, and that's throughout your entire career?
Yes, ma'am. It should be noted that I've not handled a traffic accident primarily since August of 2019.
Okay, so that was when you moved into your current capacity?
Yes.
APD?
Yes.
Atlanta Police Department. Okay, well, I would like to direct your attention to December 9th, 2018, 2:15 a.m. 7585 southbound, as the witness prior to you described the Grady curve, but I think the more technical name would be the Fulton Bridge or the Fulton exit.
Yes.
Okay. Were you on duty at that date, time, and location?
Yes.
Okay. Were you in uniform or were you in plain clothes?
Uniform, specific got my rain jacket on.
Yeah, rain jacket. Okay. And were you in a marked vehicle or unmarked vehicle?
Marked.
And what were your duties on that day, if you recall?
Responding to 911 calls.
Okay, and did you in fact respond to a 911 call?
Yes, ma'am.
Okay, can you please tell the judge what led you to the location?
I believe we received a 911 call for a vehicle accident injuries. It's 7585 southbound, well, at Fulton Street, on the Fulton Street Bridge. I want to say it was a two-car accident. There were two reports of it. One said the car was flipped over, another car said it spun out. So yeah, that's what we were responding to.
Okay, and when you arrived on the scene, did you come in contact with the person that we now know as Ross?
Yes, the person identified as Ross.
Okay, and do you see that person in the courtroom today?
I believe that is him. His hair changed a little bit, but I believe that's Mr. Dixon.
Okay, and can you identify him by an article of his clothing?
He is wearing a gray two-piece suit with a black dress shirt and black tie.
Your Honor, we'd ask that the identification be received into the record.
Understood. Mr. Ross Dixon, could you lower your mask? All right. Thank you. And officer, could you please look at the defendant and confirm that is the person who you've identified as Ross Dixon?
I believe that's him.
All right, the identity is noted for the record. You may replace your mask. Thank you, sir.
Now, Officer Stansel, do you recall what you observed when you arrived at the location?
My first interaction with Mr. Dixon specifically was he was.
Let me start you at a different point. What did you observe when you arrived at the location?
Oh, it was a traffic accident. Two vehicles potentially involved. It was, I believe, one was a black in colored Dodge Ram, heavy front end damage with airbag deployment that caused the interstate to partially be shut down.
Okay, and is that the first vehicle that you observed?
Yes.
Okay, and what happened after you observed that?
I then made contact with the male, I believe he was a male, holding an umbrella standing outside of his car.
Okay, and did you have occasion to speak with that male that we now know is Ross?
I did.
Excuse me?
Yes, ma'am.
Okay, and please tell the court about your interaction with Ross Dixon. Your arrival.
Sure. To the best of my knowledge, I remember speaking with him, asking him what had occurred. He seemed a little out of it a little bit. Asked him what had happened. He had said he was struck by another vehicle.
He said he was.
Yes, he said he was struck by another vehicle. I examined his vehicle, saw no damage to either the 3, 6, or 9 o'clock side. The only damage to the vehicle was the front, which would be his 10 or 11 o'clock side, which is where we believe he struck the median or another object. But nothing made me believe that his car was struck. There was a phantom car, airbag deployment, and speaking with him, slight slur in his speech pattern, definitely detect the odor of alcoholic beverage coming from his person.
Okay, and when you say a slight slur, just explain that. What made you make that observation, or what gave you that impression?
So in speaking with people, especially those who are under the influence of alcoholic beverage, one of the first keys is the speak pattern, how they speak. A slur is usually indicative of, it's not a medical, a documented medical condition, potentially being on the influence of alcoholic beverage. And it changes the way they speak. It's almost like a lisp or a slur. Alcohol tends to do that to people.
Okay, and was there an ambulance on the scene at the time?
I'm not sure if it had already arrived. I know Hero was there. I'm not sure if Grady had been there or not.
Okay, did the defendant indicate to you that he needed an ambulance?
No, if I remember correctly, I asked him, I said, hey, where's that blood coming from? The only injury he had was lip.
To his lip?
Yes.
Okay. And would you believe that came from the airbag?
Yes.
Okay. Now, did you ask the defendant about his alcohol consumption?
I did.
You did not?
I did.
Yeah, and please tell the court what you asked and what was answered.
If I remember correctly, I asked him twice. I believe the first time he said he hadn't had anything to drink, and then he later advised that he had consumed alcoholic beverages. I believe he said he had some wine at his home, and then he had beer while at Sweet Lounge because he was watching a fight.
Okay, so initially he indicated to you that he had not been drinking.
Yes.
Is that correct?
Yes, ma'am.
And then at what point did he change or amend that?
To the best of my knowledge, I believe I came back. There's a lot of things going on, and I asked him again, hey, just be honest with me. We're trying to get this understanding. And he's like, well, yeah, I did drink and things like that.
Okay. Now, based upon the observations of the defendant by you and of the vehicle, please tell the court what, if anything, you did.
Based on his actions and the vehicle, I suspected that he was under the influence of alcoholic beverage. He then proceeded to answer the court, and he confirmed the suspicion that led me to perform the standardized field sobriety test.
Okay, and do you recall the weather that evening?
It was raining. It was really raining.
Now, let's talk about the testing, the field testing that you did, Officer Stansel. Now, did the defendant agree to perform any field testing?
Yes.
Okay, and tell us, how did you ask that question?
If I remember correctly, it was like, I'm going to perform an assessment. You don't call it a test, but it was just an assessment to determine his level of impairment. He did not. I said he wanted to do anything. He had no issue with me doing it. He was pretty okay with everything.
Okay, and did you have to ask him more than once?
No.
Okay, and did you ask him to perform these evaluations in a certain area?
I did. We stayed where his car was. So the car was already disabled. So we stayed exactly where the car was. The only thing I asked him to do for the first step was to not lean on his truck. And I've also believed I took his umbrella. And then with other portions of the assessment, we didn't move very far. So you would have required permission.
Do you recall if this was a flat surface?
Yes, ma'am, it was flat level surface. We were on the interstate, so it was a very flat level surface. And at that point in time, it was also well lit because of all the lights.
Now, what are the types of testing that you actually asked the defendant to perform?
So the tests, there's the HGN, which is the horizontal, there's the stagnance test, then the walk and turn, and then there's a one leg.
Okay, let's start with the HBN. Was that the first test that you asked the defendant to perform?
Yes.
Okay, and have you been trained to give this test?
Yes.
And can you tell the court briefly your experience? I know you talked about Nick's experience, but specifically with the HGN, what is your?
It's a standardized assessment. After medically qualifying the person, you check for equal track and equal pupil size, your lack of smooth pursuit. So long as those are present, that means that he has no cognitive issues, brain damage, things like that. Deter him from getting on for the or mess up the validity of the test. Once you do that, then you start it. It's 6 clues. So lack of smooth pursuit, equal tracking, and the pupil size. Then from that, it is the what is it? It's the
Is there something that might refresh your recollection?
yeah, you can report. Mind you, I haven't done this in about 5 years, so it's been a minute.
That's fine. Your Honor, the state is going to ask that the incident report be marked for identification, and I'd like to show it to the officer to see if it refreshes.
Well, mark as State Exhibit 1, and you may present the report, State Exhibit 1, to the witness.
Thank you. You can take a look at your report. And once you have completed examining the report, I would ask that you then look up and let us know if you're prepared to respond.
Okay.
Okay, so now you mentioned that you would follow a standardized technique. So what is that standardized technique?
So like a smooth pursuit, the onset of stagnance prior to 45 degrees, and the staying with stagnance.
Did you explain the test to the defendant?
Multiple times, actually. One of the main issues was that you explained to the person not to move the head. The biggest issue was he wouldn't stop moving his head.
Okay, how many times did you have to instruct him to stop moving his head?
5 or 6, I believe. I raised my voice at him a couple times. It became one of those frustrating issues where I've told you this multiple times. I really need you to listen. So, yeah.
Okay. And you did instruct the defendant on what he needed to do?
Yes.
Okay. And did you conduct this test to the proper standards based on your training and experience?
Yes.
Okay. Now you've explained a bit what you're trained to look for, but let's go into a bit more detail. Tell the court or explain to the court, please, what exactly it is that you are seeking and how many clues you are looking for when it comes to the HGN or horizontal or the HGN test, excuse me.
In layman's terms, the best way to describe it is there's 6 of 6 clues. It's 3 in the right eye, 3 in the left eye. The stagnance in most basic terms is involuntary jerking of the eye based on chemical reaction from alcohol being introduced into the body. So oftentimes what you see is, so as you move stimulus, but at this point down with my finger, you're looking to see that as the eye moves and travels, is the eye almost trembling to a bit? And does it struggle to follow the stimulant? So left, you do it to the left, you do it to the right. There's 3 clues on the left, 3 clues on the right. So it's a total of 6.
Okay, and how many clues did the defendant?
6.
Okay, and that is the max, is that correct?
Yes.
Okay, and did you medically clear the defendant before you began this testing?
Yes.
Okay, and tell the court what exactly does it mean to medically clear someone prior to the field testing?
Medically clear is it's both the visual and the physical. So you're ensuring that there's nothing, you don't see anything that would stop him from being able to properly perform the test. So in this case, that's where they traffic accident, but he had no head trauma, no nothing. You ask him to wear glasses, you ask him if he has an issue with, his cognitive issue, brain concussion, things like that. I believe he said he wore glasses, but he doesn't actually wear them. He said they're more for style. And he does not wear contacts.
Okay, so he did not have any contacts and he does not wear glasses for the purpose of seeing.
Correct.
Okay. Now, did he make any comments at all during the test?
No, that I remember.
Okay, and you said you did ask him if he had any head injuries,
I believe so.
and do you recall his response?
Believe he said he was fine.
Would you have conducted the test if he had indicated that he was not okay?
No,
And why is that?
because it messes with the validity of the test. Mind you, I haven't done it in a while, but if a person struggles to stand, or if you see that his motor skills are a bit off, or if maybe clearly you can see there's head trauma sustained, you won't give him the test because it messes with the validity of the test. He was calm, he sat there with his umbrella, he didn't have any issues, he didn't immediately request a radio or anything like that.
Okay. Did there come a time when you asked the defendant to perform another test?
Yes,
And what test was that?
that would have been the walk-in turn.
Okay, and what exactly was that?
It's another test, or assessment, whatever you want to call it. Essentially, what you're doing is, essentially what you're doing is there's an instruction phase. The instruction phase is when you have the defendant go to a line or portion of road, level road of his choosing, and you instruct him to take his left foot, put it in front of his right, sit there, and you have him hold with his hands at his side as you explain to him the test. What you're looking for at that point in time is, does he start the test too soon? Can he keep his balance and his ability to just understand what's going on? So that's what we like to call the instruction phase. If I remember correctly, doing the instruction phase, he did attempt to start the test. He struggled to keep his balance, and he struggled to understand what I was saying.
Okay, and this was after an explanation of what it was that you were keeping into.
Yes.
Now, can you explain to the court in a bit more detail exactly what was the defendant's performance?
So once again, it's an assessment. You're asking the defendant to take, once the instruction phase is over, you are looking to see if he starts the test too soon and struggles to keep his balance. Once you get that done, you are now looking to see if he can, you're asking him to take 9 heel to toe steps one direction. You specifically tell him, hey, when you make this turn in the 9th step, lead foot down, series of small steps, turn around, keeping your feet on the line, and you take 9 heel steps going at the other direction. You're making a point to see, hey, are you taking these 9 steps? Are you struggling to keep your balance? Are you staying on the line? Are you falling over the place? If I remember correctly, he took the correct amount of steps going down. I think he raised his arms and struggled to keep his balance. He took the correct step coming back, but he stepped off the line a couple times and he struggled to keep his balance.
Now, did you actually show him what you wanted him to do?
Yes, I believe I repeated it multiple times. And before you start the test, you ask him, hey, do you have questions and do you understand what I'm asking you to do?
Okay, and you did receive an affirmative answer that you understood what you asked him to do.
Yes.
Okay, and how many clues are there in the walking term test?
I believe it's 9.
And do you recall how many clues the defendant existed? And if you do not, I can refresh.
Off the top of my head, I can't remember. It's in the report.
Okay. Your Honor, let the record reflect that I am showing off to his report. So same as last time, take a look. If that hand it back to me. So how many clues are there for the walking term?
There are 8. Based on the report, it was he was seen to have 5 of the 8 clues. Also, it should be noted that I had to repeat myself multiple times again because he struggled to understand. Appeared he struggled to understand what I was saying.
And so what about that? What conclusions did you draw from having to repeat yourself?
There was, once again, impairment, but oftentimes you try to figure out if a person is being difficult, that they really don't understand. The best way to ensure if someone doesn't understand you is to speak louder and demonstrate time and time again. You don't start that test until, hey, do you understand what I'm asking you to do? And they give an affirmative yes. Oftentimes, if a person struggles to follow a very specific and simple set of directions, it's either impairment or it is just your inability to just process information. So
Okay. And how many clues did the defendant exhibit?
5 of them.
5 of it, okay. And is that normal for someone who may have consumed alcohol?
Yes.
Now, is there another test that you completed?
It's the last of the assessment, which is going to be the one leg stand.
Okay, please explain to the court exactly what that is.
The one leg stand is the last of the basic standardized sobriety test. Essentially, what you're doing is, again, there's an instruction phase. You're asking the person to essentially stand straight up, feet together, hands at your side. You specifically tell the person, do not start the test until I tell you to do so. You explain to the person, hey, I need you to stand up straight, both hands to the side, take your right foot or your left foot, whatever one you pick. Put it out in front of you, let your toes 6 inches off the ground, and you count 1001, 1002, 1003, 1004, and so on. You stop. You demonstrate the test for the person, and then they do it. What you're looking for that is start the test too soon, just foot down, raise his arms, and fails to keep his balance.
Okay, and please describe the defendant's performance.
I believe he struggled to keep his balance, but that's again,
Okay, do you recall how many times the defendant put his foot down?
I do not understand my head.
Is there anything that would refresh your recollection?
The report.
Let the record reflect that I am handing the officer what has been previously marked exhibit 1 for identification. And what was your conclusion after asking the defendant to perform this last test?
4 of the 4 clues were observed, and it should be noted that you didn't count the ass here, and within 13 seconds of the test, he completely stopped. He just stopped. So,
Okay, and the maximum number of clues is 4.
4, yes.
Okay, and the defendant is shown 4.
Yes.
Now, I'd like to direct your attention. Did you perform any other tests?
I think before all of that, I think my first general interaction with him was just asking him to give his alphabet, and that was not up to par.
Then when you asked to say the alphabet, did you ask at a certain speed? Explain to the court what exactly you said.
So specifically, it's, hey, I have the alphabet A through Z, and the key is without singing the song. Traditionally, when people want to know the alphabet, they'll do A, B, C, D. No, it is A through Z without singing the song and just go. During this time, he once again slurring the speech pattern and just kind of a mumble jumble of just letters. I'm getting kind of confused.
Okay. Now, as a police officer, you have had occasion to observe people who are under the influence. Is that correct?
Yes.
Okay. And you have indicated that you've received training, but I'm curious, and for the court's understanding also, does alcohol affect people in different ways based on your training and experience?
I can, yes.
Okay, and are your observations regarding the defendant, did they include someone who had been drinking?
Yes, ma'am, specifically because one of the main things to ask them is, have you been drinking and have you consumed any alcohol beverages? Yeah, the answer to those questions were yes, I have consumed alcoholic beverages, admitted to these things, and the assessment then leads you to believe that he was drinking to the point in which it probably was safe for him to drive.
Okay, and so is it illegal to drink?
It is not illegal to drink.
Okay, and so what made this case one where you believe the defendant was actually less safe to drive because he was impaired by alcohol?
Just my general kind of observation of things. It is not illegal to consume alcohol, but it is illegal to consume alcohol to the point where it is less safe to drive. In this case, less safe to drive is any motor vehicle infraction that a normal, non-intoxicated person would not make. In this case, it was a traffic accident in which he spun out, struck the guardrail, had full airbag upon it, on a wet road. These are not things that I would say are normal for a person who's not been drinking. Another issue is that the phantom car, as I almost got a feel, telling me that you were struck by another car, but there's no damage to your vehicle that would lead me to believe that. And the only damage is from you striking the guardrail.
Now, did you ever see another vehicle or van or any other car that appeared to have been involved in this incident?
I believe there was another vehicle, but I dealt with him specifically. I saw nothing on his vehicle that would corroborate his account of events, that he was struck by a car which caused him to do what he did.
And do what he did is what?
To wreck out and crash into a guardrail, totally.
So the vehicle was stolen.
Not a mechanic, but given the damage, yes, notice, yeah, not drivable, full airbag deployment, front end is TV, yes.
Okay. Now, Officer Stansel, did you have any body camera equipment on you at the time?
I did. It was attached to my desk.
Okay, and please tell the court what APD's policy is regarding the body camera.
While it has changed, the body camera policy reads as, well, at the time, it reads that you're supposed to have a body camera on during all interactions with public and arrests and things like that, specifically during this assessment. And the call, my body camera is required to be on during the duration of the call.
Okay. Now, were you able to determine that your body camera was in fact running?
It was.
The entire incident?
Yes.
Okay. And have you had an opportunity to view your body?
Bits and pieces, yes.
Okay. And as a result of viewing that body camera, what you viewed, was that the actual understanding that you had from the incident that took place?
Yes.
I'm sorry, the incident, yes.
It's just
November 2018.
Yes, ma'am.
Okay. Your Honor, may I have just one brief second?
You may. While Ms. Marshall's story is conferring, Ms. Powell, have you made a decision as to how you'd like to proceed?
Yeah, Your Honor.
And what's your decision? Okay.
Thank you, Your Honor. Counsel, would you stipulate to the video coming into evidence?
Is the court going to view it?
Well, we were just asking, the officer hasn't had an opportunity to view my video, but if you would stipulate, we can play it, otherwise we can.
Absolutely. We can
Okay. Your Honor, since counsel has agreed to stipulate to the playing of the video,
Okay.
I can actually get it to play. Would the court like to see it this time, or would the court like to reserve and watch that?
I'm going to reserve ruling on that, and so I will review it during the course of my deliberation. Or does Attorney Dixon, do you want me to review it right now so you can then cross-examine on the video?
Please, Judge.
Okay, so
I believe, Judge, I believe in total, it's maybe about 35 minutes in total.
okay, go ahead and let's start the video.
Okay.
Just pause it. Ms. Githia, Ms. Powell has decided that she wants to accept the state's plea offer. Is there someone from your office who can help her facilitate with the documents?
I did send the plea paperwork to Ms. Bolton to see if she could print it.
Okay, excellent. Thank you. All right, we're going to mark the video as State Exhibit 2.
It has been marked, Your Honor.
All right. And the defense has stipulated to it, so it's going to be admitted as State Exhibit 2. Now you are, no. Okay, here, let me do that, and then you're gonna have to play on your
Work it from
laptop.
there. Yep, that's correct.
I'm not sure.
Yes, I press television.
Make sure your
to
monitor-
be here.
Yeah,
Make sure your monitor's on.
there we go, okay.
Thank you. And we're going to.
And now you have to, now it's all on your laptop.
Patrick, can I borrow you 1 second?
Oh, yes.
And bring your glasses.
Glasses. Ms. Powell, then you're going to be presented with some documents, and do you have a pen with you? All right, you need to review all these documents. Do you have the waiver of counsel as well with those? Okay, need to read all those and check mark the appropriate responses to the questions, all right?
Your Honor, we are going to have to call to get the password. We're not able to reach it.
Oh,
We'll try
dear.
One more time.
Okay. Yeah, my monitors are equipped. So, Miss Githia, are you on the Zoom on your laptop right now?
No.
Okay.
Judge, may I take a quick restroom?
Yeah,
break?
let's take a 10-minute recess while we get the video going, okay?
Sure.
Thank you. Five, let's make it five. Video's going.
We have a I'll let you first.
Oh. Let me put it on. All right, we're going to resume with the bench trial of State versus Dixon, 20 CR 002247Y. We had taken a brief recess to set up State's Exhibit 2. Attorney Dixon, what we're going to do is, if unless you have any objection, this is body cam footage of the officer. We can forward the video until it gets to the pertinent position, unless you want to sit here and watch the drive to the location.
No objection, Judge.
All right. Whoops. Okay. So, you can actually move your cursor to the bright blue bar on the extreme left-hand side.
Move my cursor to bright blue bar.
On the, yeah, and you can just move that bar forward. No, you don't want to move. I mean, you decide how far out you want to move out.
So once you stop it, it's gonna start somewhere else. So there you go.
All right. Officer Stansel,
Yeah.
could you describe the scene right now, what we're watching?
Okay, so that's me with a high pitched voice. This is the accident. I believe that is his Dodge Ram. That is his vehicle, and that is going to be him outside of his car holding his umbrella.
Okay.
Your Honor, my client and I are having a difficult time hearing.
Yeah.
Is it possible to turn it up?
I think we can control the volume.
Turn the master
okay.
volume gonna be computer.
Let's pause it right now.
Yeah, I believe, Judge, we should restart it to where he first.
Can you, yeah,
interacted.
can you just rewind it a little tad to where you believe?
No, so yeah, so your master volume is going to be the actual laptop. So that right next to the play button. Yeah, you got that.
This is the remote for the TV, not for the laptop.
Yeah, so laptop's max. So so the laptop is going to emit as much sound as it can. So now it's just up to you to pick whatever you want to do from the TV. So click play and you can hear it.
Okay.
Right, I'm saying you hydroplane out. It's something. No, what I said is tell him. Every witness that will watch you, you hydroplane. Yes. I appreciate it. I come back at this.
No,
I miss you guys too. Dude, feel like you're pushing about everything. Yeah, I feel like you're pushing about. Right now, so it's gonna be a great South Carolina, now. That's third ball count. Yeah, we got a truck, and they said he You ain't been drinking, right? You ain't been drinking, right? No. Promise? Yeah, I just been eating. No, yeah, I'm dead serious. Yes. Good. I bet you ain't drinking. I'm just making fun. I'm being serious. I'm not gonna play around, okay? Yeah. Okay, did you drink anything? Anything tonight? You got any alcoholic drinks today? No, I had some wine earlier today. Okay. What time did you drink that wine? At 1 o'clock. Like in the morning? No, 1 o'clock. Okay, good. So besides that, you have that more alcohol, correct? Yes. Promise. Where are you bleeding from? Okay. Are you sure? I gotta make sure. Most people, you gotta put two and two together. You don't think you put two and two together. It's also, I mean, I know that's good. I mean, to everybody that, because the thing is, I got swerved on there was a car going to my right and it swerved. I got trying to go to the left. Yeah, and I plane, I guess. Yeah, that's bad. All right. I don't know where the cars went. Everybody left. Up there. Congratulations. Congratulations. Next, give me out. Next, give me out again. I gotta make sure you're going here. Go. A, B, C, D, E, slow. Now. A, B, C, D, E, F, G, H, I, J, K, L, M, N, O, P, Q, R, S, T, U, V, W, X, Y, and Z. Thank God. Relax. I know, okay. I know you're a person, no. Relax. Relax again. You drink anything, right? Yes, sir. What are you trying to do, man? I had 2 glasses of wine. Okay, I went to watch the fight, Klitschko fight. Okay. And I had a beer, and I went and danced, and that was it. I was about to go pick my wife. What'd you dance at? That's Sweet Lounge. Okay, Sweet Lounge. Yes. So what did you drink at Sweet Lounge? Just a Heineken. Okay, so how many guys did you get? Alright, so where'd you watch the movie? At Jake's Lounge. And so you drove Jake's Lounge, Sweet Lounge, and Sweet Lounge, you had how many drinks? One. So outside of that, did you drink anything else? No, I just had wine at my house. Then I went to Sweet Lounge at Jake's Kitchen. Okay, and a drink there, and a beer there. Alright, so Sweet Lounge got a beer there. Alright, cool. Okay. Not my car. I love them too. Tiger is. Yeah, yes. Yeah. They're good car. Watch me. I'm gonna make sure he's not real quick. That's what makes us like. I am now. Listen, here's what we're gonna do. I just gotta, don't come through, so put you through an assessment real quick. Stay on this first Friday, make sure the draft trunk or any influence go for them, okay? They good? Alright, here a second. Your glasses, contacts, anything like that? Just glasses. Alright. You like reading? Are they reading glasses? Keep like okay, glasses. So you don't work all the time. You should just work for dedication. No more taxes, correct? Yeah. Do not work taxes. Good. Here's what you should do. Check your eye. Please, please. Keep your head as still as possible. Focus your eyes on the tip of my finger here. And do not move your head. You understand what I'm doing? You understand what I just asked?
Let's put a pause. Okay.
Your head. Don't move your head, just your eyes, okay? Do you understand? Don't move your head. Do not move your head. Only know, okay? Do not move your head. Go next. Sit down. Go next. Come here. Stay ready on this panel. Stay ready. Good. Yes. Here's what I need you to do. Okay. You see this nice? Right. See this nice line here? Here's what I need you to do. Take your left foot, put it on the line, stand right here. Right, face that way. Take your left foot, put it on the line. Put your right foot in front of your left in a heel to toe position like so. Just like this. Take your hands out. Let's go. Take your hands out. Okay. All right. Take your hands out. Listen. Take the left foot. What? Listen. Take the left foot. Take the left foot. Right. I'm ready to keep parents like this for. Okay. Just for now. Take your left foot. Put it down on the line. Right foot. Turn your left. Be in a position like you do. Like me. Do right here. Sir. Left foot. Right. Left foot. Is that correct? Put your right foot on your left in a heel toe position. Like what I'm doing. Hold this position. See what I'm doing? Hold this position so I tell you to do otherwise. Keep your hands at your sides now, okay? Keep your hands at your sides. All right? Okay. Do not start until I tell you to. Do you understand what I just told you to do? Keep your right foot in front of your left in a heel to toe position. Right foot in front of my left, my left foot in front of my right. Right foot in front of your left. Right foot in front of your left, heel to toe position. So that's good. Left foot, then right foot, heel to toe, keep connected. I got good. Look at me. Look, they need to be touching. They need to be touching. Good. For this position, when I tell you to begin, you're going to take 9 heel to toe steps by yourself. 1, 2, 3. Pretending that it's my 9th step. Keeping 1 foot solidly on the line. I'm going to take you through some smaller steps. Get back in that heel to toe position. And I'm going to take 9 heel to toe steps and go back. Watch your feet at all times. Keep your arms at your side and count your steps out loud. Do you understand what I'm telling you to do? 9 heel to toe steps. On your 9th step, keep 1 foot solidly on the line. Take a series of smaller steps and return to that heel to toe position. And then take 9 steps back. Keep. Listen to me. Keep your hand in your feet. Keep your hand just like you come out loud. You understand? Come on. 1, 2, 3, 4, 5. I just told you, I want to say this to you again. 9 steps. On your 9th step, keeping 1 foot solidly on the line. Take a series of slow steps. Return to the heel to toe position and come back. Let's try this again. Let's go, baby. Come on. Let's go. Come here. Come here. Come to me. That's the most. Do you understand? It's like this I take you to get it. It's like stay on the feet together and spot like this. And fight. You're not gonna get a back until I tell you to do so. Do you understand? You understand? Okay, when I tell you to do, I want you to raise 1 leg. Stand up straight. Don't tell me. When I tell you to, you're gonna take 1 leg. Whatever one you choose. Look at me. You're gonna take 1 leg, whatever leg you choose. Make that foot like 6 inches up down like so. Point it to a floor, looking down at the other side and go. Without 4, without 2, without 3, without 4, without 5, without 6. And so
Your Honor, maybe pause for a minute, Judge. We have an announcement. My apologies, Your Honor, but we received an email, a text from our colleague, Ms. Riley, that the Zoom, they were kicked off the Zoom, so I don't know if the court reporter can still hear. I just wanted to verify.
Thank you.
Ms. Greenhouse, can you still hear the proceedings in the courtroom?
Yes, I've been on the whole time.
Okay, all right. I just wanted to make certain.
Thank you.
Thank you.
Easy work back, okay? What did you do? Check the assessment best please. All right, the easy thing that you're gonna do. Standing up like so, you're gonna put your arms up like this. You're gonna lean over at the waist. You're gonna go to chest like this, put your arms like that, okay? You get up on it like this. Hold it, hold it, hold it, hold it, hold it, hold it, hold it. Hold on, over here. Yes, bro. Shit.
All right, shall we move forward the video until, is there anything else after this?
Yeah, this one is.
We can move forward to you, rest.
All right, when he encounters the defendant again? Oh, okay, looks like we're going there.
Go ahead. Go ahead. Go ahead. Miss Dixon, I'm gonna read you something. Put your hands behind your head. Put your hands behind your back. Hands behind your back. I'm gonna read you something. Okay, Georgia, what are the submit to a state of chemical testing, blood pressure, and all the substances.
You can forward that portion. All right, is there anything else on this tape you'd like me to watch other than the fact that he is being arrested at that time?
Judge, I believe that is sufficient.
Okay, we'll conclude the tape. We'll take a small pause on the trial for me to address the plea if Ms. Powell has completed her documentation. Ms. Powell, if you'd like to come forward. Officer Stansel, may I ask you to step aside and let Ms. Powell stand at the podium, please? Thank you so much. Ms. Gideon. All right. We are addressing position number 2 on our Orca bench trial calendar, State of Georgia versus Telecia, Telecia Powell, common spelling, case number 20 CR 0000719Y. Ms. Powell was accused of destroying, removing, concealing, encumbering, transferring, dealing with property subject to a security interest a misdemeanor offense allegedly on December 31st, 2018. Ms. Powell, the case was scheduled for a bench trial today, at which time the state was prepared to move forward to prove its case beyond a reasonable doubt with its witnesses. Pursuant to consideration of this matter, you have now decided to take a possible plea offer in this case. I've already advised you that you have a right to remain silent about the facts of your case. I have gone over your right to waive counsel in this particular matter and to proceed self-represented. You have also read the documentation with regards to waiver of counsel. I just want to confirm that you are choosing to voluntarily waive your right to counsel after being so advised, and that you're choosing to proceed self-represented. Is that correct?
I hesitated on signing that document. But today, as of present time, I don't have counsel, so I guess I do agree to not have counsel, if that makes sense.
No, it doesn't. Do you, after reading this document regarding waiver of counsel, and after me advising you of the consequences of representing yourself, that you're responsible for your own legal decisions, how it impacts your particular case, and so forth, do you want to choose to represent yourself willingly and knowingly and voluntarily?
And no.
So you, all I want to make sure is that everything that I've explained to you about representing yourself as an individual, understanding that you are a layperson, that you're not a lawyer, but that by choosing to represent yourself, by failure to exercise your right to retain an attorney in a timely fashion, that you're responsible for the legal decisions that you make today.
I do understand that today, Your Honor.
So you do waive your right to counsel?
Yes.
Ms. Powell, this is a negotiated plea. In other words, the state has provided a recommendation. And then after that, I will ask you some questions to make sure that if you agree to plead guilty to this charge, and that you will be accepting the recommendation freely, knowingly, and voluntarily. Do you understand?
Yes, Your Honor.
All right. If I find in any way that you don't understand, or that you are being forced to take this plea offer, or that you're not doing it freely, voluntarily, and knowingly, then I will schedule this case for trial. Do you understand?
Yes, Your Honor.
For purposes of the plea, may please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Okay. Ms. Githia.
And also, do you agree to waive a restitution?
Excuse me, I need the solicitor, please, to speak louder. Thank you.
I was asking Ms. Powell, does she agree to waive the right to a restitution hearing?
If I'm correct, that means.
All right, I totally agree with why Ms. Powell is puzzled, because Ms. Githia, if your offer from the state is that she's going to agree to an X amount, there is no restitution hearing.
Okay.
This is strictly a contract.
Okay.
You are saying, I will agree. The state is saying, in exchange for whatever you're offering, that she is on probation to only pay an X amount. All right?
I do apologize.
No, I just want to be sure that that the state, the defendant, and the court are all on the same page. The only decision she has to make is whether she's willing to accept the amount that the state is seeking to collect.
Okay.
All right? The amount that you're seeking to collect is not in dispute. Now, if she wants to make it at the point of dispute, then we don't have a plea offer.
Understood.
All right. So disregard that last question. All right. What's the plea offer, Ms. Githia?
The offer is 12 months probation to pay restitution in the amount of $3,074.03 to American Title Loans, and the probation to terminate upon completion of the condition.
Ms. Powell, did you understand what Ms. Githia just said?
Yes, Your Honor.
All right. So that means that they're asking that you be placed on probation. You'll report to probation and you'll report to probation every month. Every month that you visit probation or the office, you must pay a certain amount so that the debt of $3,074 is completed. Do you understand?
Yes, Your Honor.
And I'm going to add, and I'm going to, because you're going to be on probation, I'm going to require you to make a minimum payment of $200 per probation visit. Is that doable?
Does that go towards to probation? It goes towards to probation, or is
It
that
goes
in
towards the
addition?
loan. It goes towards the loan.
It's not in addition to?
No?
Okay. Yes, Your Honor.
And in agreeing to make a minimum of a $200 payment per month, I'm going to waive your probation fees.
Thank you, Your Honor.
Any month that your minimum payment goes below 200, you have to pay probation fees that month.
Thank you, Your Honor.
All right. Ms. Powell, do you agree that this alleged case, this alleged offense occurred in Fulton County?
Yes, Your Honor.
Do you agree to the factual basis that the state is claiming to support their case against you?
Yes.
And do you agree that the alleged perpetrator of this case is you, Alicia Powell?
Yes.
All right. And have you consumed any medication or alcohol?
No.
And have you understood the proceedings so far?
Yes.
And if you have further questions, please ask me, all right? Are you being forced or induced to take a plea offer today?
No, Your Honor.
And are you going to plead guilty to this charge freely, knowingly, and voluntarily?
Yes, Your Honor.
That was a question response. Are you pleading guilty freely, knowingly, and voluntarily?
Yes, Your Honor.
In taking this plea offer, you're going to have to give up your right to a trial, give up your right to confront your accuser, examine witnesses, challenge the state's evidence, to challenge the witnesses that are brought against you, and to challenge the state's ability to prove the case against you beyond a reasonable doubt. Are you prepared to waive these rights?
I am, Your Honor.
How do you plead to one count of encumbering a asset subject to a security interest?
Officially, no. And
I'll take a no contest plea. It really has no bearing. All right. Your sentence is 12 months probation. You'll report to probation every month. Your first probation visit will be next Thursday at 132 Mitchell Street in downtown Atlanta.
Okay.
All right.
I have the option to go earlier.
Well, the reason I make it next Thursday is to make sure that probation has all their documentation.
Okay. I get
All
it.
right. You are to pay a restitution amount of $3,074 and I think it was 3 cents. All right. And your minimum payment must be $200 per visit. And every time that your minimum payment is at least 200, it can be more, but it cannot be less than 200. You won't have to pay probation fees that month. Understood?
Yes, Your Honor.
And you will continue to report to probation. In your last month of probation, you must pay the outstanding balance due. All payments will be made directly to your probation officer, who in turn will then remit the sum to the American Title Loan. She is not to pay directly to American Title Loan. That way probation can keep an accounting. All right. No interest shall accrue on this debt while you're still on active probation.
Thank you, Your Honor.
All right. Any questions?
No, Your Honor.
Have a seat. We'll give you a copy of the disposition. She has to report to the probation office, 132 Mitchell Street on Thursday. All right, we will resume with the case of State of Georgia versus Dixon. We've already seen plaintiff's exhibit 2. Ms. Marshall Story, do you have any other further questions?
Just 1 or 2 additional. Do we need to switch back over to?
Oh, yeah, sorry.
Officer Stansel, very briefly, so based upon, the video that we just saw, where we were able to see how you effectuated, the test of the defendant, did you come to a conclusion?
I did.
And what was that?
That he was under the influence of alcohol to the point where it's less safe for him to operate a motor vehicle.
Okay, and what did you do pursuant to coming to that conclusion?
Pursuing to come into that, he was read at that time with the state's implied consent card, which is no longer used, but it's been changed since then. And then asked if he would submit to a chemical test of his breath, blood, and or urine, to which he did not want.
Did you actually make an arrest?
Yes.
Okay, no further questions, Your Honor.
All right, thank you. Mr. Dixon, your witness for cross.
Absolutely. Officer Stansfield.
Stansel?
Stansel, I
Yeah.
apologize. You indicated that it is important to medically clear the suspect because it affects the validity of the test. Is that correct?
Yes.
In that video that we just watched, can you point to a time where you medically cleared Mr. Ross?
I need you to be specific. Is that a question or a statement?
The video that was just on this court, can you point to a time in that video where you medically cleared Mr. Ross before you administered field sobriety test?
It could be the glasses, contacts, anything else like that. That is a point in time which you are allowed to advise head injuries, anything trauma like that. To the point in time, he said he had no issues besides the bloody lip.
Okay, so it's your testimony that you didn't sustain any head trauma.
What you complained about?
Yes.
Yes.
Okay. On the video, approximately 9 minutes and 16 seconds. You and Mr. Dixon were interacting. Mr. Dixon communicated that he got hit, and then you responded. You took an airbag to the head. Is that correct?
Maybe.
Also, while you were interacting with Mr. Dixon, at about 7 minutes and 22 seconds in, did Mr. Dixon not indicate to you that he felt like he got punched in the mouth?
Believe so, but in that point in time, he was also bleeding from the mouth.
So you would agree with me, in order for someone to be bleeding from the mouth, they would have to have been hit in the head in some form or fashion, correct?
Or the chin or jaw, yeah.
But that is a part of the head, correct?
Yes.
Throughout the when you initially interacted with Mr. Dixon, you indicated that you wanted to make sure he was good and conscious, correct?
Yes.
You asked him to say the alphabet, correct?
Yes.
To which he responded with A, B, C, D, E, F, G, H, 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 K, L, M, N, O, P, Q, R, X, T, U, V, Y, Z. After hearing that statement, it was of your opinion that Mr. Dixon was in good conscience at that time, or was conscious at that time.
Yes.
Isn't it also true that during your interaction with Mr. Dixon, before you performed a field sobriety test, that Mr. Dixon at 10 minutes and 42 seconds said, "I am shocked. My head is spinning. My head is shaking." Is that correct?
If that's on the video, then yes.
But it's also your testimony that you would not have a suspect perform field sobriety tests if that's an indication of head trauma, correct?
Yes.
If that is the case, officer, stand still. Why didn't you perform field sobriety test for Mr. Benson?
Well, if I believe correctly, so you're quoting his first time of reciting the alphabet where he struggled. As the court saw, he recited the alphabet a second time and had no problem going A through Z. He was also asked, he was okay, declined any medical attention. Grady was right there. At any point in time, he could have asked if he had any issues, injuries, and he declined to do so.
You would agree with me that a person could, at the scene of an accident, not feel anything, but thereafter feel pain or some symptoms associated with the injury they sustained from accident, correct?
I'm not a medical professional, sir.
Okay. Fair enough. So you also when you were communicating with Mr. Dixon, indicated at approximately 6 minutes and 45 seconds that witnesses say they watched him hydroplane. Is that correct?
Believe so.
What witnesses were you referring to?
I'm assuming either the 911 call, that 911 call context, or conversations had with other officers on scene. That's really correctly. I had a conversation with the I think she's Grady operator who advised the same thing, because we didn't. There were multiple calls. We didn't know if they were there, and then specifically based on his vehicle and his statements didn't go hand in hand. He said he was struck. There was no damage to any portion of his vehicle that would leave a person believe he was struck, and he was hyper.
Okay, so it's a general understanding from the officers there that Mr. Ross hydroplane. Correct?
Based on the on-scene investigation, yes, and conditions and everything else.
Additionally, was there any witness that communicated to you that they witnessed Mr. Ross driving at a high rate of speed?
On that part, sir, I am not aware.
Okay. Was there any witness that communicated to you that they observed Mr. Dixon driving reckless?
Directly to me, sir, no.
Stepping back a bit, when you responded to Mr. Dixon, or you stated to Mr. Dixon that you took an airbag to the head, do you not consider that to be a incident where head trauma is involved?
There can be to the face.
So it's your testimony that an airbag striking Mr. Dixon is not considered to be head trauma?
So being that I'm not a medical professional, I cannot tell you what is and wouldn't be trauma. It is a shock. It is going to be forced to the face, but it should also be noted that Mr. Dixon was able to pull himself from his vehicle, get on his phone, talk, communicate, sit nicely with a umbrella, stay calm, remain calm, and decline any medical attention. Nor did he state that he was having any issues that would lead a reasonable person, specifically an officer, to believe that he can't do something.
So although he was bleeding from the mouth and you understand or observe that his head was struck by an airbag and deployed in an accident, is your opinion that he was medically cleared to proceed with the field sobriety test?
It should be noted that you're saying bleeding from the mouth. There's a small laceration to the lower lip, which could have been caused by him simply biting his lip. But once again, I'm not a medical professional, so I can't say what caused that. And once again, if he did not want to do something or he thought he could not do something, he could have said, I don't feel it.
So,
or ask me.
So in your NHTSA training back in Illinois, how are officers trained to determine the difference between medical impairment and impairment due to alcohol influence?
So questioning and an on-scene investigation. You ask about a person's medical background, history of concussions, brain trauma, surgery, stuff like that.
Did you ask any of those questions to Mr. Dixon that night?
I specifically remember I asked him in the video show about how he felt at the moment and if he had any injuries.
Okay, but you didn't ask him specifically if he sustained any concussion or he had any head trauma, right?
No.
So Why wouldn't you ask those questions if the validity of the field sobriety test would be in jeopardy?
Simply put, your client was seen by Grady. Grady had no issues. He requested no medical issues, no medical attention, which led me to believe that he had no medical issues at the time, which make it hard for him or impossible for him or mess with the validity of the test.
When did Grady see him?
I believe so. They were parked there. I believe they got included. He never requested EMS.
All right, so let's back up so that we understand. So is it your testimony that Grady did an evaluation of Mr. Dixon before you arrived?
It is my belief, like I say, my understanding that Grady did speak to him. Now, again, he did not request Grady or did not request any medical attention from me, nor did he complain of it in anything, which could, once again, lead me to believe that he needed any help besides the small cut on his lips.
As it relates to the HGN test, based upon your training, what is the accuracy of determining impairment when administering the HGN test?
What do you ask?
How accurate is the HGN test at determining whether a suspect is under the influence of alcohol?
Are you asking for percentages?
Yeah, that's in the training.
I don't know. I have not taken, so it should be noted. I did this in 2018. I haven't written a DUI since then. It's not part of my work. It's not part of my everyday function anymore. I don't do DUIs anymore.
Fair enough. Prior to 2018, how many DUI arrests had you done?
Close to 50.
Close to 50. And were those 50 done in the state of Georgia or Illinois?
They were done in Georgia.
So it's safe to say that you were familiar and comfortable with administering a field sobriety test on the night of this incident?
Yes.
All right, okay. So with the HGN test, you indicated that what you're looking for is what's called nystagmus.
Yeah.
Right?
Yes.
What exactly is nystagmus?
Well, only one of us currently has a textbook definition of it because you're reading the book. The latest term is involuntary therapy of the eyes and people based on the chemical reactions in the body's introduction to alcohol.
Based upon your training, is it possible for a suspect who is medically impaired to show symptoms of nystagmus?
Yes.
Okay. So it is quite possible, based upon the trauma that Mr. Dixon sustained from the airbag striking him, that could have triggered the nystagmus that you observed.
Yes.
Fair enough. Okay. Okay. Going to the walk and turn. Again, the purpose of your court, you were very familiar and comfortable with administering the walk and turn based upon your training.
Yes.
Okay, based upon your training, is it proper to demonstrate and instruct us the test simultaneously to the suspect?
It's instruction and then, sorry, it is the instruction phase, then the demonstration phase.
Okay. On the video, we saw you simultaneously instruct and demonstrate the walk and turn to Mr. Dixon, correct?
No. If you watch the video, I read him the instruction after struggling to get him to understand simple instruction, he has to sit on the line, hold the position, and multitask on the play. He was then read the instructions, and then stopped, and then demonstrated. So, and it was about 3 or 4 times. So, yes.
How confident are you that you properly administered walk and turn as it relates to NHTSA standards?
I'm pretty comfortable.
As it relates to administering the walk and turn, when you are instructing the suspect to perform the walk and turn, what is the first instruction that you're supposed to give?
You gotta have to use it, and I don't remember what I made.
No, I'm asking you based upon your training, what is the first instruction you're supposed to give to a suspect?
I don't remember what I made.
Fair enough. On the video, you instructed Mr. Dixon to, at approximately 19 minutes and 40 seconds on the video, you instructed Mr. Dixon to keep 1 foot on the line with your initial instructions. Is that proper?
I should instruct him. No, I should instruct him specifically to take his left foot online and then take his right foot and then his left.
So you would agree with me that you did not properly administer the walk and turn?
I would agree that during the demonstration, actually during the instructions, I initially did not give right instruction, but then stopped myself and specifically told him what to do multiple times.
Okay. So you are testifying that you did not give the right instruction and that you gave it again, correct?
I'm testifying that I, after not telling him specifically what foot, I then specifically told him what foot, or again, exactly what he was supposed to do multiple times.
Okay, on the video, we witnessed you instruct or attempt to instruct Mr. Dixon on performing the walk and turn. And we saw him perform it not once, but twice, correct?
Yes.
Where in the NHTSA training that you received is it proper to perform the walk and turn twice?
So in this, once again, I don't know the manual, but specifically, he was given another opportunity because he's very clear he's not understanding my instructions.
Is it possible that he didn't understand your instructions because you weren't giving clear instructions?
It's possible, but when I asked if he understood what I was saying, the video statement, he said yes multiple times. So his point in time, that's when he for clarification was at that point in time, to which he did not. But I'm courtesy for him, I not only allowed him to do it again, but explained him the instructions specifically and allowed.
So the NHTSA manual or your NHTSA training tells you, a trained officer, to give a suspect a courtesy do-over?
I understand to give him a courtesy do-over, but hindsight being 2020, I should have allowed him to take his 13 or unlimited amount of steps and had that been evidence for the court to see that he failed to follow those instructions to that point in time.
Okay. Going back to HGN, reviewing the video, officers are required to do an assessment of pupil size, resting nystagmus, and tracking ability.
Equal tracking.
Equal tracking.
Right, yes.
Okay. Can you point to the specific point in this video where you made that assessment before administering the HGN?
Video?
Have we played the video, Judge?
Which portion? Actually, don't have to. So prior to, you don't have to utilize video that you're doing it. So your first pass, what you do is you doing this. So I can say that prior to doing that test, the first thing you test is are me doing that exact same thing. What's the lightest guys that is making that exact same thing?
Okay, your testimony, earlier was that, this is just me generalizing your statement, but you can correct me. Your statement was that you could determine that someone was drunk because they would, normally an individual not intoxicated would do a traffic offense. You said something along the lines of, you can determine that a person is under the influence because a person that is not intoxicated would not normally do so. Is that correct?
I think you're referencing to the DUI, let's say, portion.
Okay.
And my words, not to be taken out of context, are that less safe is simply this. It is in traffic infraction. In traffic infraction, no matter how safe, what is done. And if a person admits to being under the influence of alcohol and or drugs, that is DUI less safe. And I'm saying that, if I'm not mistaken, that normally the person not under the influence of alcohol and drugs, they do not commit traffic violations such as this.
So your understanding as an officer in the state of Georgia that a person is in violation of DUI less safe if they commit a traffic offense?
Traffic violation and or offenses. So in this case, it would have been is driving to task conditions. So there's your driving to task conditions, which causes a major fault. So upon saying that, hey, you broke, I found out yourself, you admit that you've been drinking. A reasonable person would say that your level of impairment, no matter how slight, led to your act.
Okay. Your testimony earlier was that there was a general understanding that this accident was caused due to Mr. Ross hydroplane. Is that correct?
Yes.
Could a person who is not under the influence of alcohol hydroplane their vehicle and get into an accident?
Yes.
Okay. What about hydroplaning a vehicle leads you to believe as a trained officer that a person was driving too fast for condition?
Well, it's raining. Hydroplaning is often caused by tires and contraction. Tires and contraction on roadways when they're bald or there's no friction. The lack of friction is caused because it's wet. So if you're driving too fast on a wet roadway, you will hydroplane out.
You just indicated that a person with hydroplane, if their tires were bald, that is one of the possibilities, correct?
Yes.
Did you evaluate the tires on Mr. Dixon's vehicle?
I did not.
So it's safe to say you didn't rule out the fact that it's safe to say that you did not take into account that Mr. Dixon's tire could have been bald on this side.
I did not.
Okay. So essentially, you would agree with me that it is a possibility that Mr. Dixon just got into an accident after hydroplane.
It's possible until he admits that he's been drinking.
One moment, Judge.
All right. There we go. Thank you. That's the transfer order, right? Thank you.
I think lastly, when Mr. Dixon was performing the field sobriety test, in particular, in particular, the HGN and the walk-in turn. There were moments where we observed on the video that he was blowing into his hands. On that night, was it cold?
I don't know the temperature. I don't remember.
Do you recall what the weather was outside of it just being wet?
It was raining. It was December, so it can be a bit chilly.
And it is possible for that to affect it being chilly, windy, cold, and rainy, for that to affect a suspect's performance of field sobriety test, correct?
Yes, but in this case, he was allowed to keep his jacket on. He was wearing proper clothing. His hands or his fingers appeared to be cold, but I'm not sure where that would affect his ability to walk, stand, and or perform at early tests.
And you also testified as it relates to your training. When you relocated to Atlanta, that the city of Atlanta police did not administer any DUI investigative training. Is that correct?
Correct. So there is a simple class, and they go over it and they kind of go.
So essentially, when you administer this, the field sobriety test on Mr. Dixon, you were relying solely upon your training from Illinois.
I should be held to be a national certification test, so it actually transfer over. It's not a state by state thing. National, it's a national certification. So yes.
Okay, fair enough. No further questions at this time, sir.
Ms. Story, do we have a redirect? Very brief, please.
Very brief redirect, and then we'll be prepared to call our next. Officer Stanford, does anyone have to provide enough clues to show whether a driver is a less safe driver due to impairment?
No, ma'am.
And do all of the tests, along with your observation, and assist you in making that determination?
Yes, ma'am.
Did you ever come to find out that the defendant registration was expired?
Yes, ma'am.
When and how?
I believe I ran it on my mobile data terminal in car computer. That's when I found out the registration was expired.
Okay, and did there ever come a time when you learned the defendant's occupation on December 9th, 2018?
Off the top of my head, I do not remember, but knowing me and knowing kind of how I operate, it's probably when you in the back of my car, just a nice conversation about, hey, what's going on? So that could have been it.
Did you ever come to find out what his occupation was?
I don't remember. I may or may not have.
No further questions.
All right, thank you.
Just one question, Judge.
Yes, you may, on the tag issue. That was the only thing that was not raised. That's the only area I'm going to let you recross.
The state did address the clues though, Judge.
So you've got my directive.
Okay, nothing further, Judge.
Thank you, officer. You are free to go. You're free to stay.
Can I make a quick statement?
No.
Okay, thank you.
Thank you. Next witness, and that witness is going to allocate as to what information?
Your Honor, the next witness is Officer Jennifer Knight, and she did the accident reconstruction report.
All right. And Ms. Kithia, I may impose on you one final time to summon the next witness. Thank you. All right, officer, if you could please raise your right hand, please. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
And your full name and your agency, please.
Was previous Atlanta police officer, just resigned in February, but full name is Jennifer middle name Lynn and last name Knight.
Knight, as in KNI.
KNIGHT,
Okay.
yes, ma'am.
And you were previously employed by,
Atlanta Police Department.
and were you employed by the Atlanta Police Department at the time of this incident in question?
Yes, ma'am.
All right, thank you. All right, Ms. Marsha Story, your witness for direct.
Thank you. Good afternoon. How would you prefer that I call you?
Jennifer's fine, it doesn't matter.
Okay.
Miss Knight,
I will
it's
call you,
whatever's easier.
since
Okay.
you were previously an officer. All right, Officer Knight, I'd like to direct your attention to December 9th, 2018, at approximately 2:15 a.m. Were you dispatched to a location?
I'm not sure if I was dispatched or if I overheard the accident come up over radio. So I'm not really sure.
Okay, how did you arrive at the scene?
Um,
Were you driving?
I remember driving my patrol vehicle down off of I-20. At that point in time, I think I was already going eastbound. I do remember having to come up the road about 100 feet northbound in the southbound lanes, but a tow truck had stopped traffic for everyone, so nobody was coming down. So cut over that gore, got up to the accident.
Okay, and what if anything happened next?
I don't really know. I know as soon as I got out, I tried to help block traffic, keep one lane open, and then just try to see if anybody was hurt. That's one of my first things to try to do. I could see a truck. I don't know if it was a 4-door truck. I know it was a larger, I think a Dodge pickup truck. Went to see if he was okay, and I mostly remember talking to the female that was driving in the white van because it was her birthday. Door was messed up. She couldn't get out of the car. And I knew Grady had already been out there as well. So at that point in time, I know they were checking on the female passenger of vehicle number 2. I was assuming everybody was good after that, and then we just went forward with regular accident.
What were your duties on that date?
Well, I decided to take the report after a lot of officers will get out there and start getting information. It doesn't matter who it is or whose accident it is, but I knew Officer Stanson was coming in. He's 1303. That was his assigned beat for the night, so I knew he was going to handle the accident. But I was still getting information. I don't know whose information I got first or what happened with that. So you get tag numbers and start getting information of drivers, passengers, as much as you can. If there's any witnesses.
I'm going to pause. Could you bring the microphone just a tad lower so you direct it at you?
So that's the process I went through. Just the same thing, every single accident. You try to get as much information.
And what information did you obtain from this particular accident? And if there's anything you need to refresh your recollection, I do have the incident.
To be honest with you, I'm not sure. I don't even know if I actually talked to Mr. Dixon about his information. The only thing I really remember was talking to the female in the van. So I'm not even sure if that information was relayed to me. I have his information for the actual report or not, but I do remember having to walk up to the female in the van, talking to her for a good bit, and it's raining, so we're trying to get it done quickly. So I can't say how I got his information.
And have you been trained in accident reconstruction and how to write an accident report?
Accident reconstruction, I'm not sure how in depth we took that class while we were in the academy. But yes, accident reports. Yeah.
And did you ultimately generate a report this particular incident?
Yes, ma'am.
Okay, and based on your observations, your training and experience, which we will touch on very briefly, what were your conclusions?
Well, so I'd already worked about 3 years, I think. So you see multiple accidents every night. To me, it appeared that the truck had been traveling at a high rate of speed. I know there's math problems you can do for the velocity, the speed, this and that. But just witnessing that and having witnessed many wrecks, crashes before them, the only thing that this truck had been traveling at a high rate of speed and had hit something, went all the way to the cement median to the left-hand side and went right back again into traffic, into I mean, he's crossing what, 3 or 4 lanes and then 3 or 4 lanes back that way. So even after an impact with the car and then impact with the cement median or barrier. The only damage I saw on the female's car, vehicle number 2, was her door. She couldn't get out of the door. But other than that, I knew the driver. I do remember him being somewhat not coherent. But I'm not a medical professional, so I don't know. He was walking around. I do remember that. The female was somewhat, she said she was stiff, but she didn't want to go to the doctor. It was late. Didn't want to go to the doctor that night. It was her birthday. She was coming back from her party with her friends. But other than that, I can't tell you too much more.
How long were you employed with the Atlanta Police Department?
Probably 2.5 years
Okay.
at that point in time.
What were your primary duties there?
As a field officer, Zone 3, morning watch. So field operations.
Thank you. No further questions.
All right. Mr. Dixon. Ms. McCall?
So, very good question. You indicated or you testified that Mr. Ross did not seem to be coherent. What did you observe that led you to that?
I do remember he was holding an umbrella, but just holding it. I don't remember him opening it. It's weird because it was raining. But he was stumbling around a little bit. But again, to me, you either see that as somebody's intoxicated or someone's gotten into a wreck. I wasn't aware of any injuries. Like I said, I think I spoke mostly to the lady in vehicle number 2 about the incident. But I just assumed that Grady had checked him out and had already talked to her, and they were driving off actually, or getting back in the ambulance when I arrived to talk to her.
Were you aware that there was a general understanding that the accident was caused because Mr. Ross allegedly hydroplaned?
Objection, Your Honor.
The objection is?
He's asking the witness to testify to something that someone else possibly thought. He hasn't actually explained who it is or what it is that he's referring to.
Response?
I think the question is proper, Judge, but I'll rephrase it.
I'm asking you whether you have a rebuttal to her objection
I'm
of.
just asking a question, Judge.
Okay, so objection sustained. Rephrase your question.
Did you have any reason to believe that Mr. Dixon hydroplaned?
It's possible, yes, because all of the roads are, when they get wet, everybody loses control. Everybody's going legally above the speed limit that you should be going. But I haven't seen many. This goes back to working that area for so many years and I've probably seen 100 crashes there. I've never seen anybody hydroplane, even with the rain at that location. It's a bad curve. People like to merge into other people's lanes or swerve into other people's lanes. So to me, no, my opinion or my assumption at that point in time did not make me believe or think that he had hydroplaned.
Just clarifying what you said, you indicated that you had not observed an accident where an individual had hydroplaned?
I've never seen one there that someone has hydroplaned, and I've seen hundreds of accidents at that location.
Oh,
So in my state of mind is thinking they collided with somebody.
Okay.
Now, could it happen? Yes. It was wet.
Have you ever, I guess my question is, outside of that location, this incident in question, have you ever investigated an accident where a hydroplan had occurred?
Oh, yes. Many, many times.
Okay. Based upon your experience then, let me backtrack. You indicated in your testimony that hydroplaning is caused by driving at high rates of speed. Is that correct?
It's not actually high rates of speed. You can still be going the speed limit 35 miles per hour around the curve. But technically there's OCGA law that says you have to go at a reasonable speed that you think is safe. So Was it too high of a speed at that point in time for anybody who hydroplanes? Yes. I mean, everybody's guilty of it. I'm guilty of it, even going the speed limit, but it's possible.
So, are you aware of what the speed limit was on that particular highway?
Let me see. I'm saying it's 55.
Um, so it's your position that, given the conditions, that, he would not have hydroplaned if he was driving less than the speed limit?
Also, well, like I said, that area is not known for hydroplaning. It doesn't collect the water.
You gotta
It
answer the
doesn't.
question I'm asking.
Okay, ask again.
So is it your opinion that, for him to have had hydroplane, he would have had to be going at the speed limit or higher?
If he had hydroplaned, if that was the case, yes, he would have had to have been going at least the speed limit or higher.
So that means that if he was traveling at a rate of speed of 50 miles per hour, you don't believe that he would have hydroplaned?
It just depends on how well he is at driving.
No further questions.
Any redirect?
No, Your Honor.
All right, thank you, officer. Ms. Knight, thank you very much.
You're welcome.
Anything else from the state?
No, Your Honor, the state rests.
State's Exhibit 2 is admitted. Mr. Dixon, do you have anything to add?
I would like the motion to court for acquittal. Mr. Dixon has been charged with separate offenses, Judge, and just going through them each. I don't believe that there was any testimony or evidence presented that showed that Mr. Dixon failed to maintain his lane within the marked lanes. It's quite possible, Judge, that based upon the testimony that we've heard today, he could have been driving within his lane, hydroplaned, and lost control of his car. I don't think the state has met its burden as it relates to proving that beyond a reasonable doubt, Judge. As it relates to driving too fast for conditions, here again, Judge, there was no independent witness or a bystander that spoke to the officers about Mr. Dixon's rate of speed or how he was driving. Officer Knight just testified that he could have been driving below 55 miles per hour and still hydroplane. So I think it's safe to say, Judge, whether he was driving 55 or below, he could have hydroplaned. So it's kind of hard to determine, Judge, based upon the facts and the circumstances here, whether he was driving too fast for conditions, because you can hydroplane going less than the speed limit. And because of that, Judge, I don't think there was any additional evidence that showed that he wasn't reasonable and prudent in the way that he was driving. Just because that he simply hydroplaned his vehicle, Judge, doesn't in and of itself prove that he wasn't driving reasonable and prudent, okay? Because here again, we're all experienced drivers. You get a patch of water, you turn your steering wheel too quickly, next thing you know, you lose control of your vehicle. I don't think that the state has proved that beyond a reasonable doubt. Judge.
With regards to basic, too fast for conditions.
That's correct.
Your argument is that if the individual is driving above the speed limit, that that's the only logical time that one could hydroplane?
No, my argument was, Judge, based upon Officer Knight's testimony, she indicated that he could have possibly hydroplaned driving below the speed limit.
Okay, let me rephrase my question. Too fast for condition. Are you saying the word too fast refers to the deviation from the posted speed limit?
No, what I'm referring to, Judge, is the reasonable speed based upon the statute. Well, the statute says that the vehicle is to drive a vehicle at a speed greater than is reasonable and prudent under the conditions.
So if it's raining really hard and and there is rivers of water going down the highway and someone hydroplanes, could they hydroplane at 25 miles an hour?
Absolutely, Judge.
Okay.
Yeah, I've experienced hydroplaning because, I mean, driving down Piedmont Road with the water's flooding and I'm driving at 25 miles per hour. I mean, you could hydroplane there, Judge.
Okay. So other than the basic rules, what basic too fast for conditions, what other
The first argument was to the failure to maintain lane.
thing? Okay, sorry. Failure in basic too fast conditions, what else?
So those are two. Third one, Judge, is the reckless driving. Here again, echoing some of the points that I made earlier for the first two violations that Mr. Dixon is accused of. There's no independent witness. There's no bystanders. There was no testimony that indicated that Mr. Dixon was driving with reckless disregard for the safety of persons or property on the roadway, Judge. There's absolutely no testimony to that. I did ask Ms. Deborah Jones whether she had observed him driving. She indicated that she only saw or Mr. Dixon came into her purview at the time of impact. So prior to the time of impact, Ms. Jones had not seen anything. It was just one of those crashes that happens in a moment's time. Neither Officer Stansfield nor Officer Knight testified that they believed that he was driving with reckless disregard of safety of persons. The only thing that has been testified to was that he may have been driving too fast for conditions. And that was through the testimony of Officer Knight. Other than that, Judge, there has been no evidence based upon my observations here in the court today that Mr. Dixon was driving his vehicle on a roadway in this state with a reckless disregard for the safety of persons or property. That has not been met, Judge, whatsoever. I do not believe that the state has met their burden there. As it relates to the DUI, Judge, I also believe that he should be acquitted on that as well. Officer Stansfield admitted that he didn't do some of the field sobriety tests correctly, Judge. He also testified, Judge, that if a person is not medically clear, then the validity of the test is in question. It is clear, Judge, that from looking at the video, the positions of the cars, the airbag deployment, the damage to Mr. Dixon's vehicle, that it was a bad accident. I don't think anyone here will dispute that. It is clear, Judge, that Officer Stansfield clearly observed and acknowledged that Mr. Dixon hit his head on the airbag. That came out of his mouth. He also said, the video also showed where Mr. Dixon said, "I'm shocked, my head is spinning, my head is shaking." This is in the video, Judge. Also, the video showed blood dripping from his mouth. Judge, common sense. How does blood drip from one's mouth? Something must strike someone's face, I mean, which is your head. So that in and of itself is cause for at least me to say, maybe this individual may be concussed. Maybe this person needs to be examined before I move forward with field sobriety tests. This Officer Stansfield did not testify or could not testify to the fact that he had been medically evaluated by anybody other than him making his own assessments. Okay.
By the way,
Yeah.
Dixon, I appreciate your argument. And I'm looking at the time and no. It's just a procedural thing.
Yeah.
Procedural thing. I'm going to construe your motion for an acquittal or JNOV. I'm not JNOV, directed verdict on these issues as a closing argument. We're on a bench trial. All right? I don't believe the state has anything else to have. All right? So does the state have any objection to considering his argument so far as a closing argument?
My only issue, Judge, is I would like for you to make a ruling on my motion for acquittal so that I can determine whether or not he needs to testify or not. My client needs to testify because I would have to consult with him depending on what the court's.
Oh, I thought he was not going to testify because I asked you earlier.
He may
Okay, you're right. Procedurally, yeah, that's correct. Okay, go ahead.
Yeah.
So on the DUI, in the acquittal,
Right.
I mean, on a directed verdict, why should I grant directed verdict on the DUI when I've already got an officer who has testified that he had sensed an odor of alcohol based on his own experience that the field sobriety tests were not up to snuff? I mean, the whole issue will be at the end whether they've met the burden of beyond a reasonable doubt.
That's correct.
All right. On a directed verdict, the standard is not beyond a reasonable doubt. So why is it not up to snuff?
It's not up to snuff, Judge, because for one, the officer did not perform the field sobriety test properly according to NHTSA standards. The officer admitted that, Judge. The officer also testified that the validity of the field sobriety test is in question if a person is not a suspect is not medically cleared before administering those field sobriety tests. A number of occasions through Officer Stanseal's testimony, he admitted he didn't do some things right and he could have did some things better, which ultimately goes to the validity of the test, Judge. So based upon that, those tests should be wiped out totally, okay? Mr. Dixon did admit to having a couple beers prior to the accident. There was no evidence, Judge, of how close in time to that accident when he consumed those beers. We don't know. It could have been 3 hours, could have been 4 hours, could have been 5 hours. There was no testimony towards that or evidence towards that, Judge.
That's not relevant. This is not a per se case.
Well, based upon him being considered to be a less safe driver, DUI.
Okay.
But at any rate, Judge, and just looking at things in its totality, Judge.
Okay.
We got the DUI test not administered properly. We had a motion in limine that's consented to by the state that shows that he didn't do something else right. I don't think the court should even consider it.
Objection, Your Honor, that wasn't the reason for the motion in limine or the state agreeing to it. It was because the testimony was no longer relevant based on current case law.
But Judge,
the refusal was no longer relevant.
Judge, if you read my motion is not based on Elliott. My motion is based upon procedure. You can pull up my motion, Judge.
I'm going to sustain the objections. I have no idea why the state consented to it.
All right, we can move on. But at any rate, the totality of circumstances, Judge, less safe driver, nothing in the record here again has shown that he was driving too fast, he was driving too recklessly to be a less safe driver, Judge. And so because of those reasons, I think you should also acquit him of the driving under the influence as well. So essentially, Judge, I'm asking you to dismiss all charges before the court today.
All right. I'm going to deny the request for a directed verdict. I've already heard the evidence myself. There is still the fact that the officer may not have checked off everything on a NHTSA manual does not in and of itself, and that is black and white law, does not in and of itself invalidate a field sobriety test or a test that's administered. Yes, in a perfect world, we would have evidence to outline exactly how things began from A to Z. But in this particular situation, we do not have. We have testimony that this whole situation began when there was an impact with Miss Jones' vehicle. And then after that, it's been a series of, it's possible it could have hydroplane, it's possible it could be speeding. So, but I I do take that into consideration. But on a directed verdict juncture, I'm going to deny it on the failure to maintain lane, on the basic rules too fast for conditions, on the DUI, on the reckless driving. I will grant your directed verdict on the no proper tag. So that leaves us with 4 charges. Mr. Dixon, do you still want your client to testify?
May I confer with him just momentarily, Judge?
Okay. If you both want to step outside, we'll take a 5-minute recess.
Yes, Judge.
Peter Buck, how am I doing on this?
Registration maybe.
4:42.
Okay, well, I was wondering whether you want to chase us out so people.
No, no, I'm at your service. I've got a car parked, I've got my county car parked outside, so literally I can walk out of the front door and
Okay.
leave. The reason why I relieved Deputy White, besides the fact that I'm just a swell guy, is
But let me just go ahead and stop the Zoom so that, you know.
that's fine. I'm not gonna say anything dirty. I think
the microphone. Good thing. All right, we are back on the record in State Dixon 22 CR 0024. I'm losing my sight right now. 002247Y. There we go. And Attorney Dixon, yes, sir. What's your client's position?
He is not going to testify, Judge.
Okay, he's going to exercise his right to remain silent. So we are. Do we have anything anything else from the defense?
No, Judge.
Anything else from the state?
No, Your Honor.
All right, we're going to have closing arguments. Would the state like to just conclude or open and conclude?
The state will conclude.
Okay, Mr. Dixon?
Well, Judge, I mean, I'll just echo the same arguments I made for the motion for acquittal, which, as the court indicated, the standard is different. Looking at it from the standard of beyond a reasonable doubt, I don't think the state has proven each and every element of each offense beyond a reasonable doubt, Judge, which is required by law. And I don't want to essentially reiterate what I've already said because you've heard it. But for the sake of time, Judge, I don't believe that the state has successfully proved their burden beyond a reasonable doubt for each and every charge and each and every element of those charges that Mr. Dixon is accused of.
All right. Ms. Marshall Story, if you'd like to make your closing statement, I'm ready. I'm all ears.
Thank you, Your Honor. Can you hear me from here?
I can. Can Ms. Greenhouse, can you hear Ms. Marshall Story?
I believe so. Can she just say one or two more
Testing,
words?
testing, 1, 2, 3.
Testing.
Yes, that works. Thank you.
I'll keep it at this level.
That's perfect. Thank you.
Thank you, Your Honor. The state would submit that we have proven each and every element that remains on this particular case. The evidence has shown, Your Honor, beyond a reasonable doubt that one, the defendant was drinking. First, he denied drinking, then he admitted to drinking, and then admitted to drinking a bit more. The state would also submit, Your Honor, that the officer did properly complete the field sobriety testing. The evidence was very clear on the video that not only did he repeat himself once, twice, sometimes 3 times, he admitted when he did make a mistake. But as I asked the officer, it is not one test in particular, it's all of the tests. It is the impressions made by the defendant on the officer when he first met him at the scene. It is the conversation that they held. It was the smell of alcohol. It was the slurred speech. It was the bloodshot eyes. All of that goes into concluding, one, there's really not an issue in terms of the first count, failure to maintain lanes. The very first witness testified that the defendant crossed over 3 other lanes of traffic. He was in one, crossed over 3 and hit her vehicle. So we're very clear that the state has met its burden. There was testimony from the officer that that was the impression that he received. There was also testimony from Officer Knight that that was the impression that she received based upon the report that she wrote. Your Honor, the state would go on to submit that the charge, the accusation of basic rules, too fast for conditions. Again, Your Honor, it was raining. The defendant decided, obviously, to drink and decided to drive. And there was testimony that that particular area doesn't necessarily pool in water, which is what causes hydroplaning. That, in addition to speed, obviously, and then there was also testimony that bald tires may have been a part of that. But what is clear is that one person crossing over 4 lanes of traffic clearly was driving faster than should have been driving for the conditions at 2:15 in the morning when it was raining. Your Honor, regarding the third count, the DUI alcohol, let's say, the state submits that the evidence was very, very clear. One, that the defendant admitted to drinking. 2, he did not pass the field sobriety testing. The HDN has a maximum of 6 clues. He exhibited 6 of those clues. The walk and turn has a maximum of 8 clues. He exhibited 5 of those clues. And the one leg stand has a maximum of 4 clues. And he showed all 4 of those clues. And as I stated earlier, whether he hydroplaned or not, he clearly crossed over lanes of traffic. But the issue is that he should not have been driving, period. He had been drinking, and I submit he had been drinking the day. He started at 1 o'clock in the afternoon. He admitted to that. He said he had further drinks later on while watching the fight, and then went somewhere to dance and had more drinks. So at this point, Your Honor, we know the defendant was drinking, 1, because he admitted it, but 2, the officer's testimony was very, very clear. I believe that his instructions were about as clear as you could get. And you could also see on the video, the defendant still had to have those instructions repeatedly said to him for all of the tests. Your Honor, the state submits that the defendant was a less safe driver. We believe that his driving was reckless. We don't believe that he should have been on the road based on the testing that was done. And for those reasons, Your Honor, the state would submit that it has met its burden beyond a reasonable doubt that the defendant was a less safe driver, that the defendant was driving under conditions that were too fast for the weather, and that the defendant was driving in a reckless manner. And I'd ask the court finally to please consider the testimony of our witness, the witness, Ms. Deborah Jones, who basically stated, I thought I was going to die before my birthday. For those reasons, Your Honor, we'd ask that this case, that you find the defendant guilty of all of the counts. Thank you.
Thank you. All right. The state has the burden of proof these charges beyond a reasonable doubt. And if one possible theory is just as equally possible as another theory, then the state has not met its burden of proof. This case began with a witness, Ms. Jones, who testified that out of the blue, she felt this huge impact, and then she saw the defendant's vehicle rolling, and she kept using these hand movements, like the vehicle could just kept flipping on the road. So what I do have is Officer Stansel confronting a defendant on the road who has apparently come out of a significant wreckage after the vehicle has apparently flipped quite a few times, according to the state's witness. I don't know. I don't expect Officer Stansel to be a medical professional and determine that the defendant has any kind of head trauma or trauma to his body to a degree that he should be sent immediately to the hospital. I don't expect Officer Stansel to exercise that kind of certainty. What I do expect Officer Stansel or whoever is the DUI evaluator to at least ask the necessary questions to see if it's reasonably possible to proceed with a DUI investigation. And one of the beauties of trials today is we get to watch these body camera footages, and we get to not only see it from the officer's perspective, but also from all our other perspectives. And based on all the evidence that I've seen on the video footage, based on the information I received from the 3 witnesses from the state, as well as the arguments of the defense, I don't have a problem with the techniques used by Officer Stansel in his DUI evaluation. There are many officers who don't memorize the NHTSA manual by rote. We all wish they did. They would have it tattooed on both arms, but they don't memorize these information by rote. They try to do it to the best of their ability based on their experience and training. And we as citizens hope that is sufficient in order to make sure that drunk drivers are off our streets. However, based on my evaluation, I find that there's equally possible that the defendant may have been somewhat unbalanced from the significant wreckage that he came out of. thankfully intact without significant injury to himself. I find that the state's not met the burden of proof on the DUI less safe. I do find the defendant, under the circumstances where there is his admission of alcohol consumption, where there was evidence of the adverse weather conditions and the driving conditions, that Mr. Dixon was operating a vehicle in reckless disregard of the driving conditions of the situation and the weather, that he was operating a vehicle too fast for conditions, and that the impact based on the evidence presented, not only from the information derived from Mr. Dixon from the video camera footage, that he failed to maintain lane and caused an impact with Ms. Jones' vehicle. So I do find Mr. Dixon guilty of reckless driving, failure to maintain lane, and basically driving the vehicle too fast conditions. Mr. Dixon, if you please stand. On the reckless driving, I'm going to sentence you to $1,000 fine. You will be serving 12 months of probation. You'll report to probation every month, and you will be subject to random screens for illegal drugs and alcohol. For the too fast for conditions, your fine is going to be $500, and for the failure to maintain lane, it's going to be $500. You're also going to be required to do a defensive driving class, and you will continue to report to probation for the 12 months and pay your probation fees. Thank you.
Judge, may I bring to the court's attention, Mr. Dixon now resides in Mexico? Is that correct?
No, I didn't know that. Did you all know that?
First I've heard of it.
I just wanted to bring it.
When's he going back? Monday, okay. Which will be very difficult. Because he'll be required to report to probation here in Fulton County, first time in person. And then Fulton County will be authorized to find a comparable probation place in whichever town he's in.
Would the court allow for reporting via phone or email? I'll do that. Yeah, he can go ahead and report by phone. I'll dispense with the random screens, but he's not allowed to have any more traffic or vehicular infractions for the next 12 months. Okay. So again, on the reckless driving, it's $1,000 fine. It's the failure to maintain lane is $500, too fast conditions $500. That's a $2,000 fine. That's payable. Will you be able to pay it within the next 30 days?
Yes, ma'am.
It's
Okay,
2,000.
the fine is payable within 30 days.
It's 2,000 plus.
That's fine.
Okay.
Okay,
And
it's non-reporting, so he's not paying probation fees.
Okay.
Your Honor, regarding the alcohol drug evaluation and treatment,
How
does the court propose that be done if the defendant?
I found him not guilty for DUI, so I'm not going to require that.
I thought you said.
I said random screens.
Oh, you did not say risk. I'm sorry, I thought you did.
I did say yes.
Oh, you
would.
said defensive driving.
Yes,
There was a
defensive
class
driving
involved. I'm
class,
sorry.
yes.
And how do you propose it that?
He can do that, he can do that in either Georgia, he can do it online. There are lots of programs online with the Department of Driver Services that are acceptable.
Okay.
Yes. This is an adjudication of guilty, so that would be 6 and more points on his driving record. So he's over the age 21, right?
Yes, Judge.
Okay. So please be mindful that if you accrue 15 or more points in the last 24 months, your license could be suspended.
Yes, Your Honor.
All right. Defensive driving program, you can do any Georgia program. You can do it online. You just need to make sure you send certificate within the next 12 months. You must pay your fine within 30 days from today. You must do your defensive driving class again within 12 months. And you cannot have any traffic tickets or any traffic infractions for the next 12 months. I think I covered it all. The only thing I'm going to dispense with is in-person reporting and the random screens. Thank you. That concludes the case.
Judge, just so that a client, he had a question. The initial contact with the probation officer, how does he go about it? He just calls them?
Yeah, just call them and make sure, well, can you make sure that it gets done since you are here? Or are you going back to Mexico too?
I wish.
Okay.
I wish I was going to Cabo. No, Judge, I can assist him with that for sure.
I'm sorry, did you say Mexico or New Mexico?
I live in Playa del Carmen with my family for the last 2 years now.
Oh, just rub it in. Okay. All right. Okay, that concludes the case. Thank you. Miss Attorney Dixon, can you get in touch with the probation office? And that would be at either 132 Mitchell Street or we can give you the probation information.
I definitely need that. For sure. Probation information?
Yes.
Okay.
All right. Oh, thankfully you are here to remove all of the solicitor's IT equipment, sir. Thank you so much.
Sign something else, Ms. Bolton from
All
yesterday.
right, Ms. Greenhouse, thank you so much. Have a great weekend. Take care.
Thank you, Judge Law. You too. Bye-bye.